My lord, may I have your lordship's leave to mention in regard to item number 486 for the upgradation. Yesterday, my lord, I have mentioned the matter.
Mentioning upon notice.
Yes, my lord.
What is your urgency?
Urgency is this, my lord, despite there being a specific observation passed by your lordship, my lord, the district magistrate did not consider the same for the extension of the mining lease. My lord, the tenure has all.
Pending.
My lord.
It is still pending before the district magistrate.
No, my lord, that has already been disposed of by rejecting without, my lord, giving a go by of your lordship's observation.
My lord, my lord. This is regarding illegal construction of the field.
Are you mentioning upon notice, sir?
My lord, I will inform, my lord.
No, no.
My lord, I shall bring the other side, my lord.
You have to mention upon notice, sir. That's the rule.
Item number 612, my lord.
Notice. Yes, other side should know.
Lordship.
What is your urgency? Give them.
May you permit to mention item number 505
and 609, my lord. This is the encroachment case. The private respondent informed of my bank premises, office premises.
Upon notice?
Upon notice, my lord.
Lordship.
May we permit to mention item number 505?
How many you're giving? Bunches, I find.
Lordship, item number 430. Lordship, item number 4.
Number 461. Upon notice, my lord, I am mentioning, my lord, petitioner, mining lease was granted in favor of the petitioner. My lord, petitioner's father died. But thereafter, my lord, petitioner made a representation before the authority concerned. That representation has not yet
Give them.
May we permit to mention item number 505, my lord. The Department of Public Health and Injuries is almost at the verge of completion of the construction of the project.
Are you mentioning upon notice, madam?
Lord, we shall. It is on an urgent basis, my lord.
Lordship,
You
notify.
have served the other side.
Lordship, item
Mention
number.
upon notice.
Lordship, item number 436. Lordship, upon notice I have mentioned unauthorized construction. Lordship.
Give the number. Mr. Mukherjee.
Notice of the
Grateful. Litigation was pending, so your lordship needs to direct go out of list. The allegation that I have constructed in the land of the acquired by the railway. Now, lordship, the public interest litigation has been exposed. Now, lordship, I want to let this motion.
Are you mentioning upon notice?
Yes, the notice.
Item number 188 and item number 138. This is the mining lease, my lord. While, my lord, in the month of October, my lord, money has been deposited, but still now, no.
Serve notice upon the other side.
Two matters.
My lord, item number 160.
What are you mentioning?
My lord, private disponents are making construction in front of my house, my lord.
Give the number.
My lord,
My lord, item number.
I am declaring this matter in the despite of the hardball pilot of 20. November, 22nd November, direct this matter to appear.
It's a hearing matter.
Hearing matter, matter is appearing in the list. That matter, where the Honorable High Court passed. But in spite of that, we are able to find that. Should Australia is admitting the matter.
My lord, item number 168 of today's list, my lord, this is the second writ petition and the authority is not complying your lordship's order. And the
Why a writ petition? It should be a contempt application in that.
my lord, the authority is telling that it is out of his jurisdiction.
Are you mentioning upon notice?
Yes, my lord.
My lord, for upgradation, my lord, item number 437 and 39, my lord, the land deeding, my lord, being in the midst of my lord acquisition proceeding without.
Serve notice.
My lord, only the street, my lord, is to be, my lord.
You have to.
My lord,
Serve and come.
My lord, I'm mentioning today's list item number 375, my lord.
Upon notice.
I've served notice. I'm asking for upgradation. This matter deals with livelihood rights of the petitioners who are fish workers. Despite there being legal notification that you cannot charge tax jolcor to fishers who are fishing in river waters, a private respondent in this matter is still charging them illegally, despite all the representations to the
So it's
authority,
an allegation against the private respondent.
as well as the state respondents, my lord, because despite repeated representations, their own notification, they are not implementing. Kindly allow.
My lord, may I permit to mention an application for extension of interim order, my lord.
Upon notice.
My lord, actually this matter, all the three matters are running in today's list as item number 50, 51 and 52.
So why are you mentioning?
My lord, already my lord, the interim order has been vacated, my lord, on
You
30th
should have
November.
served notice before
Lord,
mentioning.
kindly allow this.
No.
may I have your lordship's kind leave to mention today's list?
Without notice.
No, the notice has been served, lordship.
Notice has been served, Lordship. This is a matter where your Lordship, pursuant to your Lordship's order, there was a hearing conducted by the respondent number 2, but the respondent number 2 has not considered the petitioner's title over the said plot, which has been obtained by a decree itself, and they have just passed the reasonable order on the basis of the record of rights only, Lordship. And the respondent number 1 is constructing construction over the said premises, which is owned by the petitioner. Lordship.
Yes, call the days list, please.
Lordships. My lord, the same mentioning, my advocate. on
Sufficient
record.
mentioning taken for the day, tomorrow again.
My lord, he's my advocate on record. He's just sending
Yes,
the postal receipt.
maybe come back tomorrow.
No, ma'am, my lord has already allowed the mentioning, my lord. Only the postal receipts he was scanning. I mean the same matter. Item 375, ma'am, I just mentioned.
If the mentioning is allowed, so be it. Yes, days list.
Item number 1. Madam, Mr. Parthodev Burman is appearing for the respondent. If it can be taken up tomorrow, my lord, subject to your lordships.
It's for extension.
Extension of entry.
My lord, we have a lot of things to say in that probably it is not a simple extension.
Granted by the division may extended by this honorable court for.
My lord, there is another proceedings before a division bench which said something else. I'll then show the orders.
This order been set aside by the.
No.
Not been set aside, but probably some.
Any court.
That is extended for a limited period.
My lord, will kindly hear me for a minute, my lord. My lord, what has happened, my lord, the petitioner herein has a leasehold right, had a leasehold right rather, that has expired, had a leasehold right over a portion of an undemarcated water body. The interim order was that in that undemarcated portion, nobody should disturb them. Taking advantage of the entire of this order, for the entirety of the water body, they did not allow anybody to cultivate catch fish, my lord. So, my lord, we were affected. We went for we filed a writ petition. This is the order.
The interim order is in respect of the undemarcated portion.
Yes.
Demarcated portion, but my lord, there's a later division bench order which says that in respect of the rest of it, they cannot disturb me.
We are not saying so.
That's there.
The division bench already said that.
My lord, only my submissions, ma'am.
This matter has nothing to do with the other division bench matter.
Nothing to do.
The problem is that the other division bench matter
This is extended in terms of a direction of the division bench. So if you have any difficulty with that, you have to approach the division bench.
I cannot have any difficulty with the extension, but under the garb of that extension, the entire water body cannot be taken over.
You have moved the other division bench on this.
The division bench has also spoken. I'll just show for once, the order of the division bench.
Application has been filed for vacating interim order. So long it is filed. No affidavit has been used.
For once see the
hearing matter, affidavits are ready, I believe.
Yes, keep it for hearing.
I fix a date for hearing. Let it be extended for a limited period. Right?
Obliged.
Hearing, I'm not sure whether affidavits are completed or not. I have to take instructions.
Reply is there.
Affidavits are complete.
It's complete. Yes. I find the affidavit and
I
So that serves the purpose?
only the order of the division bench may be recorded.
Not out of this matter.
I do not. I object
Not
to
out
that
of this matter at all.
My will.
That is also in respect of the same.
My will kindly see for once.
Order appeal is not preferred.
For once, my lord. My lord will kindly see.
That was another writ petition.
Another writ petition regarding the same plot of land.
Nothing to do.
My lord will kindly see for once. I'll just show the relevant portions. The second paragraph,
Getting the matter hard in a matter.
Matter
he has not filed any vacating application.
My lord, kindly see for once, my lord. The writ petition being such and such was preferred by the respondent number 1 to 6 herein, ventilating a grievance that the appellant herein is interfering with the pisciculture of the private respondent, writ petitioner. That is asked, my lord. Mr. Bhattacharya, my learned friend, appearing for the appellant, who is a private respondent in the writ petition, submits that admittedly such and such acres of water body had been settled by the government in his favor by executing a deed of lease, and possession was handed over.
For that we are paying the
Yes.
this court.
Yes. Let me read, my lord. Failure to appreciate such fact, the learned single bench passed an interim order directing the appellant not to interfere with the pisciculture of the writ petitioner and the other rights in respect of 304 acres of Beal, my lord. Mr. Dev Burman, who was representing my client, appearing for the writ petitioner, denies and disputes the contention of the appellant and submits that the learned single bench, being satisfied that a prima facie case has been made out by the writ petitioner, was pleased to pass an interim order and there is no infirmity in the same. He further submits that
saying all these things without record. Let him file application, be filed for that.
what is let me place the case, my lord. Thereafter, of course,
It is not
of
your
course,
case. It is my case.
it is.
You have no application here. No affidavit is here. You are saying all these things from the air.
He is submitting in reply to your application, sir. Please wait. Let him complete. Yes.
But firstly, my lord, this lease has not been extended. Secondly, my lord, this very specifically this records that regarding my portion, they should not interfere, and they were using this particular order.
Stated that regarding your portion, they should not interfere.
My lord, will kindly come to the second last page. I'll just show this learned single bench because this says it will not interfere with the order of the interim order of the learned single bench. That is why I'd like.
The bench's observation.
My lord, will kindly the second last page, second paragraph from the top, my lord. Having heard the learned advocates of the parties, this court of the view is of the view that the instant petition cannot be disposed of without exchange of affidavits. It is not disputed that the area of Beal is 504 acres. This is the subject matter of this writ petition also. The respondents have their right of pisciculture in respect of 119 acres. In respect of 304 acres, the petitioners and their other rights have their rights of fishing. At this stage, while admitting the writ petition for hearing, this court directs the private respondent not to interfere with the
remaining portion.
For the remaining portion. My lord will kindly make it clear for that for the
No, that already been recorded by the division bench.
Order itself. That
Division bench also recorded that.
My lord.
Of Justice Original Bench is division bench.
Yes.
Why don't you read the order of Justice Division?
The garb of the order, they are also encroaching upon the remaining portion. You have to file a petition for repeating. Simple. I think it's a date for hearing. I don't think this is at all in this matter.
The only thing is that even the lease has expired today. Probably they are rank trespassers.
27th of February.
Rank trespassers.
2023.
Using this order, the entire.
By your lordship.
The problem is that the area is not demarcated. The area is not demarcated for which.
Matter at the moment. If the interim order be extended, I'll fix a date for hearing. Come back. Affidavits are exchanged. Let us hear out the matter once and for all. Okay.
The only thing.
Heard learned counsels for the parties. Paragraph. Affidavits are complete. Paragraph. Let the matter report a can extension to can 9 of 2023. They have auditor. Can 9 of 2023. Let the matter appear under the heading Group 1 hearing on 17 January.
My lord.
Hearing. 17 January 2024. Paragraph. The interim order granted earlier is extended.
All the three matters may be fixed on the same date. All the three matters which are appearing today, my lord.
It's already running analogous.
My lord.
The interim order is extended to 31st January 2024 or until further orders, whichever is there.
In our writ petition also the interim order is expiring on 15th.
Where is your writ petition?
That is 18190 of 2023, my lord.
Item number?
Item number.
You've not mentioned for extension of the
my lord.
Tomorrow upon notice to the other side.
My
It
lord.
will not be accepted.
I'll give the notice to the other side.
As a motion, I think.
My lord.
So if you require an extension, mention tomorrow.
My lord, well, I'll give notice and mention tomorrow.
Good.
Can for extension can disposed of. Can disposed of. Can record order.
No. আপনাদেরটা মেনশন করতে হবে।
Yes, next.
At number 4.
Lord, I am for the petitioner, my lord. My lord, the difficulty, my lord, is that, my lord, after, my lord, the passing of the order, my lord, I was pointed out, my lord, that the plot number, my lord, is wrong. My lord, not only in the order, my lord, but in my representation and my repetition as well. So, my lord,
So how I
my lord, my lord, cannot, my lord.
No order need be passed
My lord, an application may be filed, my lord, on my behalf, my lord, that it be
after the disposal on a separate dag altogether.
not as a plus the plot number, my lord, is, my lord.
See what you can do. Yes, a separate plot number altogether. It's a separate subject matter.
Yes, my lord, something.
No order need be passed.
Grateful. My lord, only, my lord, one thing, my lord, liberty, my lord, may be passed, my lord, for, my lord, separate representation, my lord, and the further repetition as well.
Cause of action
Separate
altogether.
process.
Separate
Well,
subject
grateful.
matter. Next.
Item number 5.
I'm for the petition. That's the contempt application. Notice has already.
Appearing for the first time.
No, the notice already served.
Notice served.
Yes, sir.
দিদি কি ছুটিতে আছেন? ছুটিতে? বলারও প্রয়োজন মনে করে না। Yes, where is the service? It was not complete on the earlier date.
ঠিক দিলাম তো রে। ঠিক আছে।
All of them are contemners. Respondent number 6 is the alleged contemner.
Yes, sir.
And you have implemented everyone, all the respondents. Yes.
Yes, sir. We had. Only the respondent number 6 should be there.
So why have you implemented all of them? There was no direction on them.
No, I have only served the copy to the respondent number 6 only.
Your cost.
But the cost title is all the parties.
Then how is that possible? All of them cannot be termed as contemners.
Lord, sir, please give the direction.
And where is the service on Anil Kumar Singh? You have to serve him in person. This is a contempt application. Yes. Where is the service?
May I consider the affidavit service?
You have served the office of the executive engineer. You have not served Anil Kumar Singh.
That is served, but that was not affirmed, Lord. Anil Kumar. It is served upon the Anil. But not affirmed. In course of the day, I have to file, Lordship, that one. And Lordship, may please to give the direction to the respondent. That is matter related to 2021, Lordship.
Yes, what direction?
The rule may be.
Please complete service and come back, sir. You have not served at all.
এইটা এফিডেভিট না করে কোনটা এফিডেভিট দিয়ে দিস কে জানো? আরে যেটা পড়ার সেখানে এফিডেভিট না করে কি বলবো? যেটা এফিডেভিট হয়েছে সেটাতে নেই অন্য এফিডেভিট।
And please correct the cause title.
Yes, sir. Leave may be granted.
On prayer of the applicant petitioners, comma, leave is granted to correct the cause title of the contempt application. Paragraph, since a service upon the alleged contemner is not complete, comma, let the matter stand over till 21st December.
Yes.
21st December.
Kindly, Lordship, prior to 21st,
Allah, you'll not be there, 21st. 20th?
Yes.
20 করুন।
20 না 20th, 20. Get
Next.
My lord, 6 and 7, my lord, kindly takes it up after vacation. My lord, we had filed a contempt, they have filed a review. But my lord, there was a direction, my lord, to file an opposition to their stay application.
ready.
But that is not ready. My lord, the lady was admitted in the hospital, she could not come.
On prayer of the applicant petitioner, the matter is adjourned. Paragraph, let the matter appear under the same heading on 15 January.
Grateful, grateful.
At number 8.
My lord, item number 8, I am for the petitioner. Petitioner does not want to move the the contempt application since he got the certificate, my lord.
Complied with. It is submitted on behalf of both the parties that the order under contempt has been complied with. Paragraph, in view of the above, the contempt application being CPA and such is disposed of. Paragraph, there shall however be no order as to costs as in certified website.
Grateful, your lordship.
Eight and 9 both.
8, only 8.
This is 8.
Number 9.
My lord, 9, I am appearing on behalf of the petitioner, my lord. My lord, kindly give me liberty to add as a contemnant the executive engineer, my lord, PWC.
Why?
My lord, actual district magistrate, on his part, he has complied with. My lord, but ultimately purpose has not been
Was
served.
direction upon the executive.
Yes, my lord. My lord, kindly come to the page number, the original order, my lord, page 14, my lord.
Second respondent was
Page,
directed.
page 14, my lord.
Second respondent was directed. Who is
Yes,
the second?
yes.
That is the district magistrate. So how can you add
My
someone
lord,
else as a
my
contempt?
lord, actually, after that order was passed, my lord, then 10-4 was filed by the respondent. 10-4 was pending. After then, I came before your lordship for contempt. 10-4 was disposed of. Ultimately, that order was not complied with, my lord. Mother order was not complied with, my lord. This is the direction for devolution.
I cannot add a new person as an alleged contemptor in a contempt
The
application.
separate complaint application.
Yes. Mr. Butterman?
Yes, sir. Proceeding has been initiated.
10-4 has been proceeding initiated, proceeding over. 10-4 has been disposed of. So why aren't they implementing the order?
But we have, my lord, asked the, my lord. So whether implementation partner, we have to take instruction, but the 10-4, my lord, proceedings, my lord, the order has
That is over. The petitioner says so.
That is over.
That has to be implemented.
Thereafter, my lord, that have to take instruction. Status, my lord.
Please take instructions and come back. I'll keep this pending.
This one was upon the respondent to the district magistrate, he has concluded his part.
It
Thereafter,
will
what
serve the
happened, my lord?
purpose.
Yes, my lord.
No, my lord.
Implementation has to be done.
Yes.
That has to be done, my lord.
So please take instructions and come back.
Grateful.
It is submitted on behalf of both the parties that in compliance with the order of this court, the district magistrate, Purva Medinipur has disposed of the application under section
Well,
10(4)
1st November 2023.
of the West
Order
Bengal
on-
Highways Act 1964 on 1st November 2023.
Yes, ma'am.
Stop. Learned counsel for the applicant petitioner submits that the order is yet to be implemented. Paragraph, learned counsel for the state respondents seeks to take instructions with regard to implementation of the order. Paragraph, let the matter appear under the same heading. On 15th December, please ensure compliance in the meantime.
Yes, madam. Grateful.
Yes, sir.
Next.
At number 10.
I am the petitioner in this matter. Either Joseph Kedintek.
I appear
This
for
is the order passed by your lordships earlier.
the respondents.
Now the
Assignment.
matters have been assigned to your lordship.
Yes.
This is the order, my lord. Initially, I moved before your lordship, but a similar repetition is almost on the same issue. Although pair are something different, but subject matter of the plot is same. Here, my lord, I have challenged the violations of section 17 of the Act. So, my lord, I understand, my lord, that I have to serve notice upon
Notice
the
of-
ASG. I am the
Yes.
ASG.
No,
So, my lord,
it's a
kindly,
central act, so it's the
Oh, it should be the ASG.
yes.
ASG, that's why I've said ASG.
Yes.
So, my lord, let a date be fixed, early date may be fixed, because it is a 2004 matter. And my lord, your lordship knows, my lord, I have cited you on one judgment of your lordship in the Karnataka High Court judgment that is pertinent to my lord section 3J of the my lord, the National Highways Act, which is akin to section 17 of the my lord, the Metro Railways Construction Works Act 1978. There, my lord, the section 3J was declared ultra vires. The similar point I have taken in this matter. So, my lord, moreover, and another thing is this, my lord, I have been deprived from getting the compensation from the highest value. Instead of that, my lord, I was awarded on basis of the average calculation, which is not permissible under the law. That is the merits of the, my lord. Kindly fix up a date, my lord, an early date, so that I can serve upon the, my lord, the ASG and come back, because other respondents are appearing.
Lordship, I mean, at the first instance, Lordship, the matter was taken out of the list for assigning. Lordship, I think we need an opportunity to file an affidavit in opposition.
That's why I am saying that
Then
until
Lordship
and
will
unless
kindly
ASG
pass me
appear,
no,
until
he will, a notice has to be issued to him and directions for affidavit are also required. That is
Let
right.
me pass an order simultaneously, because why waste time?
Yes.
Let there be a direction for affidavits as well.
Yes.
As well, that
And
is
my
what
lord,
I'm saying.
and my lord, kindly fix up a date.
Yes, I will.
Both
Fix
the
up a
matters.
date will be difficult.
My lord,
Let affidavits be completed, then
my lord,
please
kindly,
mention
my lord,
after that.
because my lord, it's a 2004 matter. My lord, in the
I'll
month
grant
of
you liberty.
kindly, my lord, in the month of January, kindly fix up any date in the month of January.
I'll grant you liberty to mention upon completion, upon exchange of affidavit. That's
My
what we're doing on.
my lord, my lord, my lord, kindly give me that liberty, my lord. I will mention before lordship.
Heard learned counsels for the parties.
My lord, affidavit of service be
Paragraph.
kept on record.
Show the affidavit of service. Since vires of section 17 of the Metro Railways within bracket construction of works bracket closed Act, 1978 is under challenge, the petitioners are directed to serve copy of the writ petition along with annexure thereto upon the learned additional solicitor general and file affidavit of service on the adjourned date. Paragraph. Learned counsels for the respondents submit that respondents seek to use affidavits in opposition in this matter. Paragraph. Affidavits in opposition be filed within 2 weeks after the vacation.
2 weeks.
2 weeks after the ensuing vacation. Stop affidavit and reply, if any, be filed within a week thereafter. Paragraph. Let the matter go out of list for the time being with liberty to mention.
But
Lordship, in the tagged matter, 2004 matter, affidavits are complete. Lordship,
no, in that matter, my lord, I have not challenged the virus, but affidavits are complete in that matter.
Affidavits are complete.
Yes, this is in respect of the first matter only, where my lord, I have challenged the virus.
Issue is the same.
Issue, my lord, of what happened, I tell you, lordship.
Can we deal with both the matters
Yes,
together?
both the matters simultaneously, both the matter, my lord, both the matter.
Deeply.
Next.
Item number 12.
My lord, this is my application. You once আমার লেখাটা কোথায় আমার লেখার পাতাটা কোথায় আরে আমার পাতাটা কোথায় My lord, once your lordship was kind enough to deal with the matter and your lordship disposed of the matter entirely of setting aside the my lord, the past my lord, the order passed by the special land acquisition officer and directed him to consider the matter, taking into consideration the order passed in the by Justice S.P. Talukdar, as his lordship then was. Before I proceed further with this, my lord, I will like to place the judgment of your lordship as well. Before that, I'd like to draw your lordship kind attention to the record of rights once.
Have you handed over copies of the judgments to the respondents?
No, I have annexed.
Oh, you
I have annexed. Yes. That is the part of the writ petition. Earlier, there was a part of the writ petition. Yesterday, was in a boy. Kindly turn to my lord. The annexure P2, page 88.
88?
88.
Yes. Yes.
My lord, this is the record of rights prepared under section 44(1) and finally published in terms of section 39 of the West Bengal Estate Acquisition Act 1953. You'll also kindly see the note in the right hand column that this is the certificate under section 44, subsection 2 of section 44.
Yes.
Now, Lordship, kindly have a look at the section 39 and 44 2.
শান্তনু
এটা
Yes,
জজসাহেবকে
yes,
দিন তো,
acquisition.
এটা দিন।
উনি দিচ্ছেন, নিয়ে নিন। আচ্ছা। Yes.
No, Lordship, kindly have a look at the section 39 once. Preparation of record of rights. Subject to the provisions of subsection 4, the state government may, for carrying out the purposes of this act, may an order directing that a record of rights be prepared in respect of any district or part of a district, that the record of is prepared and finally published under the chapter 10 of the Bengal Tenancy Act is not applicable for me. A notification in the official gazette for an order under subsection 1 of this section shall be conclusive evidence that the order has been duly made. Then, my lord, turn to section 44.
Yes.
Subsection 1. When a record of rights has been prepared or revised, the revenue officer shall publish a draft of the record so prepared or revised in the prescribed manner and for the prescribed period, and shall receive and consider any objection which may be made to any entry therein or to any omission therefrom during the period of such publication. So, meaning thereby my way of understanding is this, my lord, that either for the purpose of first time or revise, but in both the cases, my lord, I have to be sub notice, or a notification is to be published, inviting objections. Now, my lord, kindly subsection 2. When all such objections have been considered and disposed of according to such rules as the state government may make in this behalf, the revenue officer shall finally frame the record and cause such record to be finally published in the prescribed manner and make a certificate stating the fact of such final publication and the date thereof, and shall date or subscribe the same under his name and official designation. And that exactly what has been done in our case. Kindly see, certified to be a copy of the Khatiyan number Sajana finally framed and finally published under subsection 2 of section 44. This is he is under the signature of his prescribed this certificate. And your lordship will find the left-hand column, the name of the right. That is my predecessor interest. There is no dispute to this. Now, lordship, kindly see some of the lands involved in. Can you turn to page 91?
Yes.
2292, your lordship will find from the third from the top.
2292, yes.
Then from the bottom, my lord, 2290, 2291, 2289, 225. There are all these are plots. But what they did, there was my residential plot, residential house on a plot. There I have been drive out from my residence, and they forcibly, my lord, the collector took away the possession, and they are running an office over, government office is running over there without paying any compensation. Moreover, my lord, on my plot, there is a finding of by your lordship as well as the Justice Talukdar, as his lordship then was, that flyover has been constructed on my land. Moreover, the revenue officer who adduced evidence, he has said this is a royalty land. Now that they took the plea that of section 29 of the act, that this is a leasehold property. Lease was granted in favor of the colliery. So therefore, my lord, I am not entitled to have any right. To this, my lord, I submitted before your lordship. The moment section 4, my lord, published, all the land vested with the state. There are two things. One is subsoil and one is surface. Subsoil right, I cannot, in view of section 4 of the West Bengal Land Reforms Act, I cannot claim any right. Neither I have claimed any right in this writ petition, not ever in towards my claim. Only I have claimed compensation in respect of the surface right. Now, they have all along proceeded with on the basis of the section 29 of the Act of 1953. If you lordship kindly turn to 29 once.
Yes.
In determining the rent payable by an intermediary in respect of any land, which such intermediary is entitled to retain possession under subsection of section 6, the revenue officer shall give to such intermediary an opportunity of being had and shall consider any representation that may be made to the proposal of the revenue officer. The rent so determined shall take
You are reading
effect.
29 of the 53 Act?
Yes, 29 of the 53 Act.
All leases of mines and minerals?
Yes, yes, yes. Oh, sorry, my lord, I was reading the rules. Yes. Minor is a notified area granted by an intermediary subsisting immediately before the date of vesting shall, with effect from such date, be deemed to have been granted by the state government to the holder of the said subsisting lease on the same terms and conditions. Suppose, my lord, I was holding a lease under X. The moment this act came, I will be the lessee under the state.
Yes.
This has nothing to do with the, my lord, the surface land. That's why, my lord, 44(2), I have the certificate has been granted in my favor. I was allowed to retain the land under section 6. I retained the land within the prescribed ceiling limit. That's why certificate was granted. This is not otherwise. If this would have been a leasehold property, this certificate would not have been issued. Now, lordship, kindly see the page 178, annexure P3. My lord, a portion of this retained property was earlier requisitioned. My lord, may I put it to myself, if this is a vested property from the date of vesting, if it is a leasehold property, I would not have been served with a notice under subsection 3 or section 3 of the Act of 1948. Only they could do the there is an order for resumption of my lease and my lord 10% of the compensation. But I was filed and section 8, went up to district judge, compensation enhanced. They did not raise any objection about my title, right, title and interest. If you lordship kindly turn to annexure P3, 178, page 178.
Yes.
Can you see, my lord? This is the, my lord, the notification. This is the notice under subsection 1 of section 3 of the Act of 1948. Your lordship will find this is the RS record and such, and jail number is such and such. And nowhere it has been mentioned, because, my lord, this is the pencil of law, that state government cannot acquire his own land.
Yes.
Cannot acquire his own. There is hardly any scope for serving any notice under section 3, because the property is being requisitioned, not even acquired. Then Lordship kindly see the next, the case number your Lordship will find at the top, just by the side of the order, that 88R stroke 65 to 66. Next, your Lordship will find the plot numbers at the bottom, 2508, 2569 and 2586. Your Lordship got it.
2568, I think, not
Ye-
0.
Yes, no, one of the 2568 at page 178,
Yes.
254, 2568 or 48, my lord.
6869 and 86.
69 and 86.
170.
Then my lord, Lordship kindly turn to page 179.
Yes. This is another LA case.
This is another proceedings. Your Lordship will find the case number is 39R stroke 7071.
Yes.
Now, Lordship kindly see the plot number is 2289, 2290, 2291, 2292. Meaning thereby, these are all written land from the malord, the record of rights which I have annexed. So this is not their case. No, these are the land you are enjoying. You are the riot, but the same surface and adjacent surface land, I cannot be set term to the lessee and the land belongs to the colliery. Now, my lord, Lordship kindly see the page, my lord, 199 and annexed at P5. This is the, my lord, the first I move this honorable court. The learned advocate for the petitioner submits that the respondent number 3 land acquisition collector Burdwan be directed to treat a copy of the writ application as representation of the petitioner, consider and dispose of the same in accordance with law by reason order. The learned advocate for the respondent has no objection to allow the pair made by the learned advocate for the petitioner. Under the circumstances, I dispose of the present writ application by the following order. The respondent number 3 is directed to treat a copy of the writ application as representation of the petitioner, consider and dispose of the case in accordance with law by affording just, fair and reasonable opportunity of oral hearing to the petitioner and all other interested persons and parties, including the other respondents by reason order within a period of such and such. Then, my lord, in compliance of this, hearing was conducted and this is the order passed on, my lord, by the Special Land Acquisition Officer on 18th of August 2003. Kindly turn to page 202 at annexure P7.
Yes.
The reason order of LA Collector Respondent number 3 in the WPO number as per order of the Honorable Justice Mr. D.P. Kundu of Calcutta High Court on such and such. Today is fixed for declaring the above order. The order of the Honorable High Court was received on 9th July 2003. I then and there order for searching of the LA cases. After all LA case number 5 are 63, 3970 and 2469 are found out. Then the petitioners are informed under this office memo number such and such. The revenue officer kindly mark this manner the gentleman, Sri I.A. Khan, SDLRO, office revenue officer attended the hearing on 4th of August 2003 and then 11th August 2003. Sri Khan reported that all the documents relating the procedure taken from Sri Sunil Kumar Mukherjee, now deceased, under the West Bengal State Acquisition 1953 could not be found. Kindly mark this portion, my lord. Whatever records they have collected, whatever I supplied them. There is no other record according to this, not even the order of detention. So, my lord, I have supplied them my lord, the certificate issued under section 44(2), along with the my lord, the record of rights. So, and my lord, moreover, they have never initiated any proceeding under section 44(2) small a. Never. So he filed one letter memo number such and such, praying for at least 2 weeks time to find out out the very old records. I sent letter to Sri such and such to state advocate to record to pray for time to such and such. Now, Sri Aya Khan Revenue Officer SDL Asansol filed Hajira as usual. Sri Shoibal Kumar Mukherjee, who appeared with other family members, argued the LA collector is only one of the respondent. Ultimately, we filed Hajira not during the hearing, but in the office for taking a receipt. I was very much surprised to know that Sri kindly skip over. Here, the WP is treated as petition for this hearing. Now coming to the examination of actual case, Sri Sunil Kumar Mukherjee got a mining lease of vested land vested under the Estate Act 1953 for 990 years on 1st 12 1899. Kindly mark this portion. I got the lease not on the vested land. I got the lease in the year 1899 when Estate Acquisition Act was not there. I was a lessee under somebody else. 1953, when Act came, then pursuant to the notification under Section 4, my right vested with the state. And on the self terms and condition, I was allowed to continue with the lease. So this is absolutely wrong. But subsequently, the said mining lease was working in 1955, but subsequently stopped in 1956. So after the closure of the mining of North Colliery in and around Asansol Mouja, they should have recorded the surface right in their own names. Well, it's shocking. I shown to your Lordship the record of rights. And certificate was granted by the revenue officer. Stands in the name of my predecessor. Now he is saying this. The compensation for the royalty land is already received by them, but now they are claiming the compensation of 3.45 acres of land of the parish such and such. So they themselves are contradicting. One hand they are saying the royalty land, a portion for I have received the compensation, and for other portion for 3.43 I am asking for. Now where is the wrong in it? This cannot be the case, my lord. The portion of the land is a vested land and this belongs to the colliery, and surface land belongs to the colliery, and other is royalty land. No. Next, my lord, actually, the underground right of any land always vested with the government. Correct. I am not disputing to that. So when colliery work is stopped in 19C, how they can claim the compensation of the underground right? Lord, I have never. He misdirected himself deliberately. I have never sought for any compensation for the that compensation for resumption of the lease. Still, the revenue officer submitted then one note of advisory committee was sent to the Department of LRA for notification under Section 29 of the Act. So 29 is dealing with the lease. To find out the said notification, he prayed for time. He argued that as recommendation regarding the mining lease was sent to the government by the advisory constituent such and such, but no subsequent record is available after passing of time on nearly 40 hours. The petitioners also failed to submit any confirmatory proof, hence the claim of the petitioner fails. Record of right I have produced. Initially, they have accepted that they are proceeding with the basis on the records that I have submitted to them. They don't have any record. Now they are saying they are proceeded with the Section 29 on the basis of the surface. I am claiming my compensation is for surface land and subsoil land. And my lord, I could not prove anything. Although they are saying the lease deed with them, everything is with them. Now, my lord, and this portion has been dealt with by my Justice Talukdar, I will show to your lordship, and by your lordship as well. Regarding the claim of their house, this is what I am on. House situated on plot number 2542 of Asansol Mouja, he could not show the original Rayati Khatiyan to me. On the contrary, the said plot number is found in Appendix 1, page 29 of the petition, a property of North Colliery. Well, can't be. Because I shown to your Lordship, my lord, that page. One second, Lordship, I'd like to trouble your Lordship, my lord, once. কত বললেন 2542 না পেজ দেখ তো কোথায় আছে এটা খুঁজে বার করে আমি তবে দিচ্ছি Well, kindly give me 1 minute time, my lord. I'll show your lordship, my lord. The 25. এটা বার করতে So therefore, my lord, I will show to your lordship, my lord, later on. 25, the Asansol could not, as property of the North Colliery as a Dakholkar, hence the claim of the petitioner fails. Regarding the claim of the petitioners about the compensation of the plots of flyover at Asansol, the petitioner did not submitted any proof of royalty land. On the contrary, Sri I.A. Khan, revenue officer such and such, submitted that the said flyover is situated on plot numbers 2481. Yes, my lordship, kindly turn to page 101 once. 101. Two five four to my lord, second last but one.
Yes.
Pass two.
Yes.
And that is the finally published record of right. And there is no denial to this. This is illegal, but this is wrong or something like that. And they have not initiated proceeding for review under section 44(2)(a). Now, lordship, kindly see. On the contrary, see I.A. Khan, revenue officer, at page 204, I was reading. The said flyover is situated on plot number 2481, 2482, 2483, 2515 of Mauja Asansol. Now, lordship, kindly turn to 2481. Your lordship will find at page 101. Two 481 Rasta. Recorded as Rasta. Kindly see.
2481 is Rasta, yes.
Yes.
Tramline.
Next, my lord, 2482 at page 100. Two 482, your lordship got it? Danga. But a fourth from the top. 2482. Page 100.
Not this 24, it's 14 something.
No, 24. My lord, that is corresponding to RS.
Oh. 2482, yes.
2482. They are relying on the RS. My lord, this is the CS, then corresponding to RS. Then, my lord, 2483. Your lordship will find the next just above that, 2483.
Yes.
Next, my lord, 2515 at page 89. Your lordship, can you turn to page 89? Two 2515. That is, my lord, the sixth from the bottom.
Yes.
And these are the records my lord have produced with them. And they are admitting that flyover has been constructed on this. When this was constructed, my lord, there was no story of vesting or anything. Only they are saying that they are proceeding with the section 29. I am not entitled. And for this, since I now could not produce the original one, so I am not entitled. My lord, subject to your lordship correction, I am putting it to myself. Even assuming that I am not the owner of the property. Even then, I am entitled to get the compensation. Because nowhere in the act, your lordship will find that owner will get the compensation. That is the interested person.
Yes.
Then Lordship kindly see. Next, my lord, document. Hence, the claim in this case also seems to be superficious. In this case, several officers like the ECL, DCO, and CO may also be consulted, but due to shortage of time, it was not possible. Kindly see. He is disposing of an application pursuant the order of the Honorable Court to give complete justice. Now he is saying that is for shortage of time. I will not serve any notice to them. Then it was not possible. This is a very old and hopelessly barred by limitation. Time and again I argued before Lordship, my lord, so far the compensation part is concerned, limitation will not apply. It's a continuing cause of action. Still, I tried to pass a reason order which may look meaningful and reasonable. So such and such, my lord, my application was dismissed. My claim was dismissed. Now, Lordship, kindly turn to the next page, 206.
Yes.
My lord, this is the order passed by Justice S.P. Talukdar, as his Lordship then was, where my lord, in a writ petition we have challenged the earlier order. Grievance of the writ petitioners as ventilated by the learned counsel on their behalf relates to alleged illegality on the part of the respondent authority in passing the order dated 18th August 2003 at page 103 of the writ petition. Appears that the special LO and LL collector Bardhaman, in compliance with the court's earlier direction in WP number such and such, took up the matter for consideration and passed the said impugn order. Heard the learned counsel for the petitioners who submits that it was not right on the part of the authority concerned to hold that the writ petitioner could not produce proper document in support of their claim for the compensation. Inviting attention to the court to the said order, it is submitted that the petitioners are well equipped with the copies of the arrest record in support of their claim, that the petitioners are the owner of plot number 2481, 2482, 2483, and 2.1. The authority concerned seems to have not taken into consideration the fact that the flyover in question is admittedly situated on the aforesaid plots, which was recorded in the name of the predecessor of the writ petitioners. It is further submitted that others standing on the same footing have already given compensation for acquisition of the said land or for the purpose of construction of flyover. Mr. Banerjee, the learned counsel for the respondent authority, submits that such special LLO collector may not be the appropriate authority for dealing with the same. I do not think that such an issue can be raised at this belated stage, and particularly when the said authority did not choose to raise such point, and in view of the clear direction of this court order, Mr. Banerjee further submits, it is necessary to ascertain as to how such acquisition land was made. After taking into consideration of relevant facts and material submission made on behalf of the writ petitioner, I find no reason as to why present dispute has to be kept alive, while ignoring the submission of the state. Alive for such a long time, if for the purpose of construction of the flyover the said lands have been acquired, and if the petitioner established the claim that they are the owners of the said land, it was thus acquired for the public purpose, they are required to be paid compensation. Next, in case the authority could not do so in lieu of non-ability to the non-production of the relevant records of right, the same can be taken care of immediately, since the present writ application has copies of the said arrest record annexed. Thus, the present writ petition is disposed of with the liberty to the writ petitioner to submit a fresh representation before the same authority, being the special LO collector, and if such representation is made within a period of 4 days from the date, then such authority must consider the same in the proper perspective and course of the light of the observation made herein above, and take appropriate action and appropriate order. It is for the writ petitioners to establish their claim, and the relevant document is indicated earlier. The entire process answers. So my way of understanding is this, my lord. Even assuming the records are not available with them, they will proceed with my record. So I submitted before them. My lord, accordingly, my lord, I made a detailed representation before them. Then, my lord, lordship kindly see the next order. At page 234.
The representation is considered.
Yes. Now, my lord, the relevant order, because earlier, my lord, they are proceeding with this is this. Yes. Kindly turn to, my lord, the ultimately this my representation was disposed of on 16th of July 2009 at page 239.
Yes, 16.
The case is taken up for today for passing order. The writ petitioners and other interested parties, they have been heard. The phrase representation submitted on 19th of January 2009 along with written statement by the writ petitioner has been gone through. Peruse the Solomon order dated 15th of August, 15th December 2008 passed in WP number. Gone through. The copy of the RS record and RS Khatian number such as Asansol, PS District Bardhaman. My lord, just pause for a moment over here. If the land belongs to the state, the Khatian number should be 1.
Yes.
Cannot be, my lord, 126. Now, my lord, in paragraph 9 of the writ petition, it has been stated by the writ petitioners that a flyover has been constructed over plot number 2481, 2482, 2483, and 2415 of the said Moja without initiating any acquisition proceedings according to law and without paying compensation due and payable to the writ petitioner. In order dated 15th of August, the Honorable High Court Calcutta was pleased to pass direction, giving liberty to the writ petitioner to submit a fresh representation before the same authority, and if such representation is made in a period of 4 weeks from the date, then such authority must consider the same in its proper perspective and the course of the light of the observation as made therein before, and take appropriate action and appropriate order. Thus, from the order date of the order 15 December 2008, the stipulated 4 weeks time ends on 11 January 2009. For obvious reason, the writ petition is submitting the fresh representation on 19 January 2009 has violated the same Solomon order, Honorable Court. The writ petitioner in the fresh representation submitted on such and such, and in the supplementary affidavit in opposition had mentioned his address such and such. In the cost title of the writ petition being WP number, and in the cost title in connection with the order they passed in such and such, the address of the writ petitioner has been mentioned as 88 Sharad Bose Road such and such, but he has not made anywhere whisper that his address has been changed and present residential address is such and such. In the written statement, he has already clearly submitted that on.
This was dealt with in the earlier writ petition.
Yes. No, why I'm saying is this, why, how? Because that is a very relevant. He has proceeded in a different angle in this while he disposing the asset, and after passing of your lordship, he took a different. That's why I'm placing this. Now the matter whether the writ petitioner's next matter 241 is entitled to get compensation for utilize the land being plot number such and such, or the aforesaid purpose come for consideration. It appears that the Sushil Kumar, he has said, now kindly see. It appears that Sushil Kumar Mukherjee, the PDC, interest of the writ petitioner, got a mining lease for a long term with effect from 1899 in respect of the land and recorded in RS Khotian number such and such. It appears from the written statement submitted by the revenue officer, the office of the land, and the land officer Asansol, that the suit plots being RS plot number 2481, 2482, such as, and others were part and parcel of the surface area held by the Mosil Koreli under the ownership of Sunshil Kumar Mukherjee. Absolutely wrong conception, because I tell you, Lordship, if it is vested after the state coming into force of the State Acquisition Act, I cannot be the owner of a colliery. At best, I can be the lessee of a colliery. colliery under the ownership of the entire land of the North Colliery was recorded in RS Khotian number and is a Khotian number such and such. In terms of section 29(1) of the West Bengal State Acquisition Act 1923, all these mines and minerals in a notified granted by an intermediate substitution immediately before the vesting and such from such date be deemed to have been granted by the state. So you are contradicting yourselves from this statement. That is my case also. Then, my lord, sub 16. It reveals from the written statement submitted by the revenue officer of the Office of the Subdivisional Land and Land Defense Officer Asansol that the Mining Advisory Committee in a meeting held on 3rd of October 1989, where the representative of Eastern Coalfield Limited and Sri Lavanya Kumar Mukherjee ex-lessee were present, took resolution and recommended for resumption of the entire area of the various count, resumption of lease. Because I have never surrendered my ownership. You said in a meeting that I am not running the factory, it is running the colliery. So we will resume. We have very well. You resume the lease, mining lease. To terminate the lease of on the land or disclosed in the schedule enclosed therewith, including the subsequently, all these collieries has been nationalized. Plot number such and such, section 29. The grounds government order is made part the area more or less of the land, including the suit land comprising the Lunari by Lalit, completely different footing. All along, he has proceeded with the subsoil land. All along. Then, my lord, kindly see page 243, which is a very important, my lord. Why I am saying this, he has all along proceeded with the, my lord, the subsoil right. Therefore, the last paragraph. Therefore, in exercise of power conferred by section 29 of the said act, the governor is pleased to terminate the lease of the land of Mosiali Colliery. Now, my lord, just kindly recapitulate, my lord. My record of right finally published, certificate issued by the revenue officer. If there is any omission or there is any illegality or any error, that can be reviewed. That too, my lord, on that day, my lord, I understand, my lord, 30 years or 50 years. Or then, my lord, review upon serving a notice. Because once kindly, lordship, kindly, one for my satisfaction, kindly turn to, my lord, section 44(2)(a) once. Kindly, my lord, once section 44(2)(a) once.
Yes.
An officer specially empowered by the state government may, on application within 9 months of his own motion within 60 years from the date of final publication of the record of rights, or from the date of coming into force of the West Bengal State Acquisition Second Amendment Ordinance 1957, whichever is later, revise an entry in the record finally published in the accordance with the provision under subsection 2 after giving the person is an opportunity. He can revise. My lord, I shown to your lordship, this is the finally published under subsection 2 of section 44.
But no step has been taken.
Nothing. That is not their case even. Then, my lord, so therefore, my lord, therefore, in exercise of the power conferred by section 29 of the said, the governor is pleased to terminate the lease of the colliery measuring 83.40 acres, including the suit plot of the said Mouja for failure to do by pursuing the development work at any point of time since the date of vesting. Absolutely wrong. I shown to your lordship that a record of rights stands in my name. And this was, no proceeding have ever been issued under section 44(2)(a). They have proceeded with section 29, which says, my lord, the surface subsoil land lease. I was lessee under the state, the date of notification, and that was terminated. Surface land cannot be terminated. I was never a lessee under the surface land because it says, my lord, the vesting in two types. One is surface land. Section 6, I will be allowed to retain with the notice. Choice of retention is there, subject to other than tea garden, etc. entirety and the tank fisheries are there. Subsoil land, I cannot retain. Lease will continue. Then, my lord, thus, 244.
Yes.
Thus, from the discussion made above, it is crystal clear that the petitioners have not a case related to the acquisition of lands under Land Acquisition 1894. The suit land, including other lands of North Police, have been resumed by the state government in terms of the provision of Section 29 of the West Bengal State Act 1953 with effect from the area. Mala, kindly mark this portion. The entire area 83.4. Rather, this property was purchased by way of auction from the court. Forget about that. Now, my lord, a portion of the land which was utilized twice in the two different proceedings, I was paid compensation as a owner. Then, my lord, the Special Land Acquisition Parliament is not the competent authority under the said Act of 1953. Petitioners may take steps for getting compensation as per provision of said Act 1953. My lord, I am not asking for compensation for resumption of my lease or for termination of lease. If that is available, I will take care of that. That my specific case is without initiating any proceeding. So question of proceeding the Act of 1894, 1899 does not arise. Without initiating any proceeding. Then, my lord, I challenge this before your lordship. Kindly turn to my lord, page 294.
290?
My lord.
292.
294.
Yes.
The writ petition have assailed the order passed by the Special Land Acquisition Bardhaman on 16 July 2009, rejecting the respondent submitted by the petitioner before the authority. The petitioner claimed to be the recorded owners of the plots in question, having 1/3 share therein, along with the performer respondent, and submit that though the land measuring about 84.19 acres in the plot in question was utilized by the state government for the purpose of construction of flyover commencing such and such, and GTO design, no compensation has been paid to the petitioner despite several requests made by them. The petitioners claim compensation in terms of the right to fair compensation such and such by setting of the order. It is submitted on behalf of the petitioner that portion of the plots in question, including the surface and subsoil rights, were vested in the state under Section 4(5) of the West Bengal State Acquisition Act 1953, as well as in terms of Section 29 of the such and such. The record of rights issued in favor of the your lordship has dealt with all of my submission as I have made before in this judgment. So I will not waste my time to this, my lord. Then, my lord, paragraph 5. In LA cases initiated by the state government respondent 50, 63, 64, 55, 66, 77, for acquisition of the portion of the plots owned by the petitioner, compensation was paid to the predecessors upon completing the proceedings. The entire exercise being done after the notification of 1954. The flyover appears to have been constructed on the portion of the land owned by the petitioner by a notification issued under subsection 3(1) requisition on 30 July. The plots in question were requisitioned by the government and subsequently utilized for conversion to construction flyover. This suggests that though the subsoil right of the petition in question was vested in the state, the petitioner and the predecessor continued to have right title interest, and they have not challenged this in the division bench. They have not challenged this, the finding of your lordship. So, my lord, they are being stopped from reopen the issue. The order imprinting is silent regarding the record of rights published in the name of the petitioner, their predecessor retention of portion of the plots of land. There is no whisper in the said order as to under what provision of law notice under the Act of 1890 was issued, despite the respondent claiming the plots to have been vested in the state earlier. Since it is evident from that the flyover has been constructed on the plots owned by the petitioners, it is incumbent upon the state government to consider the case of the petitioner and determine and pay to them for the same. Per contra, learned counsel for the respondent has submitted that the plots in question comprised in North Kuleri, including subsoil right therein held by the petition interest of the petitioner and the performer respondent vested in the state free from all encumbrances under Section 5 of the West Bengal State Acquisition 1953. The said predecessor became direct tenant under the state government from the date of vesting in terms of Section 29 of the Act of 1953. The fiduciary interest of the petitioner was granted mining lease in respect of the plots in question, which were part and parcel of the surface area held by the North Musiali Colliery. The lease being terminated by the government and possession of the land taken over by the order passed on 16th of November 2005. The entire land having been resumed by the state in terms of Act of 1953, the petitioner cannot be said to be the possession of the surface area of the land. The petitioner therefore entitled to take appropriate steps for compensation under the Act of 1953 and not under the Land Acquisition Act 1894. But the same repetition, the findings of the special labor. No, not a single any other argument or document they have relied upon in rejecting my claim. Only they are proceeded with Section 29. That is the whole case. It is not in dispute. Now, hard learner, it is not in dispute that the subsoil rights of the plot in question have been resumed by the state government. The bone of contention between the parties in this with regard to the surface right, the petitioners claiming to be the owners thereof, and the responding urging that such rights have been resumed by the state under 1953 Act. In explaining issuance of notice under Section 3(1), the learned counsel for the respondent has submitted such notice can be issued in the event of incumbents upon land vested in the government. Unheard of. Whole principle is this, my lord, their contention and your lordship negated this. But state government cannot acquire its own land. Therefore, my lord, notice under subsection 3, Section 3(1) does not arise. If you own this land, the question of acquisition does not arise. And for the purpose of acquisition is a condition precedent for serving notice for acquisition under Section 3. So far the 1948 Act is concerned. The learned counsel for the respondent submitted that such a notice can be issued now. Next. Then, my lord, your lordship has dealt with the entire thing. Then, my lord, kindly turn to paragraph 10, inner page 5 of the judgment of your lordship. In an earlier repetition being WP number to the filed by the petitioner, a coordinate bench of this court by an order passed on 15th of December 2008 granted liberty to the petitioner to submit a fresh representation before the concerned authority and directed the authority to consider the same in its proper perspective and in the light of the observation made in the order. Pursuant to the said order, fresh representation submitted by the petitioner and was disposed of by the order impugned. The order impugned demonstrates that the record of rights published in favor of the petition were perused by the authority, but there is no reflection in the order order as to the manner of consideration of the same or whether the document are considered at all. I will show your lordship, my lord. The same thing has been repeated once again. Kindly mark these 3 lines, my lord, that the order impugned demonstrates that a record of right published in the favor of the petitioner were perused by the authority, but there is no reflection in the order as to the manner of consideration of the same or whether the documents are considered at all. The order is also bereft of any finding with regard to the issuance of notice upon the petitioners under Section 3(1) such as much after the alleged vesting. The order gives a detailed account of written statements submitted by the revenue officer in the subdivision office such and such, and is in fact the reflection of the said report. The case made out by the petitioners have not been dealt with by the authority by a speaking order, and the order rests solely on annual of the report of the revenue officer. The direction of the coordinate base has also not been adhered to in the said order. Since the petitioner claimed to be the owners of the plots in question on which the flyover has been constructed and rely on several documents in support of their claim, and also as according to the petitioner, other owners similarly circumstances with the petitioner have already been granted compensation, the authority ought to have taken such facts into consideration and dealt with the contention of the petitioner by a speaking and reason order. The impugn order lacking the same is required to set aside. The authority need to revisit the case upon considering all relevant documents and submission made by both the parties before it. Pass a speaking reason order within a considerable period. The authority, kindly mark that portion. Authority ought not to have held that the petitioner have no case related to acquisition of land under the land without assigning reason therefore. Now, my lord, kindly see. Page 235. না 235 তো হবে না
235
না না Madam, kindly give me one.
Mr. Pan, you'll take a little more time, I believe, in this matter.
Madam.
Other matters are all waiting. Will you continue some other day?
Madam. Kindly please.
Mr. Dey is appearing in this one. When will you come back?
Madam.
When will you come back? We have.
Madam, the lady is 85 years old. Melody, I am not getting. I am out of my residence. Government is merely running over a office over there, and without payment and compensation, claiming to be this is the vested property. 14th of December.
December.
Obliged to yes.
But you can at least complete your submission.
Yes, my lord, 14th. My lord. And my lord, at the top, my lord, little written at the top.
Yes.
At the top, my lord. Kindly, my lord. Because this has been marked by your lordship, was kind enough to mark this portion, considering the health of the petitioners, my lord.
Yes, yes.
My lord.
For learned counsel for the petitioner. Paragraph, let the matter appear under the same heading for further consideration. On 14th December 2023, fairly at the top.
December. At the top, man. Obliged.
Item number 13.
My lord, in this matter, Mr.
Yes.
And in this matter, Mr. Orko Kumar Nak appearing in behalf of the state, my lord. Probably, I'm not.
My lord, is that matter Mr. Mitra was addressing, my lord? Is that matter where, my lord, that ULC, my lord, the date on which the matter was to take place, it was not fixed, my lord.
Yes, yes.
You were supposed to be, Mr. Mitra was here, my lord. He had to leave, my lord. My lord, can it be fixed another day, my lord? He's now stuck in another court. We'll finish our arguments, my lord. We were ready. Only thing, my lord.
Shall I make it not today only?
Only not today, my lord. Will your lordship fix it maybe on?
Substantially heard.
My lord?
Substantially heard.
Substantially heard. Your lordship can fix it on Monday, Tuesday also, my lord. No problem, my lord, if it's convenient.
What further?
We were going to place the judgments and, my lord, and conclude our arguments.
12th December?
12th December. 12th December. Obliged.
On prayer of the petitioners, the matter is adjourned. Paragraph, let the matter appear under the same heading on 12th December 2023.
Tally on top. Tally on top is that. Obliged. Get put.
Item number 14.
14, 15 and 16, Lord, I appear for the petitioner.
Yes.
But there are connected applications.
Respondents, Mr. Siddiqui.
My lord, in this matter, my lord, this is the challenge of the virus challenge 2016 of this, my lord. mines and minerals concession rules, my lord, it require, my lord, affidavits is required. My lord, even my lord, in this matter, my lord, Learned Advocate General is
Lord, what had happened is, Lord, your lordship was hearing out other virus matters also. Lord, one virus matter, Lord, went up in appeal. Lord, that appeal was pending. Due to the pendency of that appeal, Lord, all these matters were adjourned sine die because the result was important. Now, Lord, that appeal has been disposed of. I have indicated in my application that appeal has been disposed of. And Lord, the main matter has been directed to be heard out, Lord, after filing of the affidavits. Now, Lord, that can be done, Lord, by tagging up these matters along with the Lord main writ petition. WPA 42. No, Lord, that's a different one. Directs affidavits to be filed, Lord, so that as and when the matter is ready, I can come back, and in the meantime, I'll serve on the Advocate General.
You've not served the Advocate General as yet.
Lord, at that point of time, it was not required because the matter was pending. So we were all waiting, Lord, for the matter
Let
to
there
be
be
heard.
simultaneous directions.
Yes,
For
yes.
affidavits as well as service.
Yes, 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 yes. Affidavit ডিরেকশন করে নিচ্ছি সার্ভিস ডিরেকশন করে নি আর যখন ম্যাটার রেডি হবে ওই ম্যাটারটার সাথে আসবে একসাথে শুনে নিন
কিন্তু ডিফারেন্স হচ্ছে ওই ম্যাটারে কনসেশন রুলস আর এখানে অপশন রুলসটা চ্যালেঞ্জ আছে
You are challenging virus of rule.
Lord, concession rules as well as Lord, the auction rules. And
Yes.
in that matter, only the concession rules were challenged.
My lord, he has challenged the subject to question my lord friend. In this writ petition, he has challenged the West Bengal Mineral Auction Rules 2016,
Also,
which is a necessary concomitant to the Mineral Concession Rules 2016. Because he says, my lord, that you cannot fix the base price subject to question my learned friend.
Lord, may I
That is
file
his
the
case.
affidavit of service, Lord, on all the
So
three matters?
these matters are, my lord, interlinked. Because in those cases, specifically Rule 38 and Rule 61 of the Mineral Concession Rules 2016 has been challenged. But in
And
this
my
case,
writ
he has
petition
challenged the entire auction.
In addition,
Auction rule.
Entire auction rules.
Lord, I say that the framing is itself bad and it's overlapping the main Mines and Minerals Act.
Yes,
Lord,
that is your case.
Yes.
Since virus of the West Bengal Mine and Minerals within bracket auction rules 2016 is under challenge, comma, the petitioner is directed to serve copy of the writ petition along with annexure thereto upon the Learned Advocate General and file affidavit of service on the adjourned date. Stop. The matter needs to be heard on affidavits. Paragraph, affidavit in opposition be filed within 2 weeks after the vacation.
2 weeks, it takes us.
Within 2 weeks after the ensuing vacation.
Grateful.
Stop. Affidavit in reply, comma, if any, comma, be filed within a week thereafter. Paragraph, let the matter go out of list for the time being, liberty to mention.
Lord, directs
Other
the matter
matters
to
fixed.
be appeared with the hearing.
Mention, I'll consider.
Very well.
আমাদের এখন এজি নেই মাথা আমরা মাথাহীন
Upon completion, mention.
Lord, the other thing is
The list becomes long on this.
the applications can be disposed of.
What are the applications about?
Lord, the applications were with respect to Lord, including the matters in the list because directions were there to go out of the list. So, Lord, I had made application for inclusion in the list. Those can be disposed of. Can one. Lord, I have served the affidavit services, Lord, I filed.
Can one touch it?
আমরা পাইনি তো ক্যানভানটা
I do not find the application in your file. Can one shall
এটা এক্সট্রা কপি থাকলে দিয়ে দাও বিল করতে হবে বলছো
No, it's not in the file.
তোমাদের কি হবে দাদা
বলে করবি
Acha. Do you have a copy of Can 1?
Lord, I have copies, Lord,
I do not
only one
find
copy,
it in
but
the
Lord, that will do, I think, Lord.
I'll just dispose it.
Yes, yes.
I don't know.
হ্যাঁ
Can 1 of 2023 is disposed of.
Lord, affidavit of service may be kept with the record. Lord, I have filed.
Affidavit of service. You filed this today?
Yes, yes.
Very thin to the affidavit of service. Same order in 14, 15 and 16.
all.
Grateful.
এইটা একটু করে দিন তো, এই ক্যানটা সিন্স ডিসপোজড অফ যেখানে বললাম না, তার আগে করুন ক্যান ওয়ান অফ, হ্যাঁ আছে আছে, ঠিক দরকার নেই, ফাইলে দিয়ে দেবেন, এটা ফেরত দিন।
I'm grateful.
14, 15, 16, same.
14, 15, 16.
When are the other matters fixed?
Lord, no
The main
specific,
matter.
no specific date has been fixed, Lord.
So
The
let it
reason,
appear as and
yes,
when it
absolutely.
happens.
Matter, that is Kajol Ghosh. I don't remember that writ petition number. Learned, then Learned Advocate General, my lord, he had concluded his submission. Mr. Anuruddha Chatterjee, who was appearing for the writ petition, he was supposed to give the reply. Your lordship had heard the matter at length.
Yes, yes, I can recall. Yes.
ওর মধ্যে 3861 challenge ছিল।
That matter was appearing before the division, right?
No, my lord, that was another matter. My lord, something unusual happened. My lord, I'll tell you, lordship, I was appearing in that matter. That is called Ghulam Mustafa, something like that. My lord, that matter against non-granting of interim order, the writ petition, my lord, the writ petition has preferred an intra-court appeal. That intra-court appeal initially came up before the Honorable Division Bench, presided by my lord Justice Shomadhar, as his lordship was there in the. My lord, in that matter, by consent of the parties, their lordships were pleased to direct both the writ petitions and the appeal will be heard by the Honorable Division Bench. Subsequently, due to change of determination, this matter came up before the Honorable Division Bench, presided by my lord Justice Mantha. But we were not able to appear on that particular day. The learned senior counsel appeared for the writ petition, my lord. He tried to, my lord, assist the Honorable Court with regard to these facts. But the Honorable Division Bench, my lord, said that since the writ petition has still not been decided by the Honorable Single Judge, so the matter has again been remanded back to the to your lordships. Possibly it will come before your lordship again.
No, I informed him that that matter was dismissed.
Honorable Justice Shomadhar's orders was that both the writ petition and the appeal will be heard.
Anyway,
But
the
Honorable
sequence is not
Slight
concerned.
confusing.
It is
But
very
not,
confusing, my lord.
not for
After
your
I came-
lordship to
after-
invest your lordship's mind at this
That
point of
matter,
time.
the sequence is not
My lord,
concerned.
since- my lord,
So let it-
since
let
I
it
was
come,
not
let us
present,
see.
my lord, it is my
Yes.
But since I was not present before the Honorable Division Bench, could not, my lord, submit before the Honorable Division Bench that your lordships have, but the order is that it will be heard by the division.
Anyway,
This
let us not
This is
comment
very
on that.
complicated, my lord.
Let
But
it
your lordship
come.
is having the determination, my lord, it will come.
Well, let it come, I'll deal with it.
Read, grateful.
It's a 2017 matter, I mean, after 2017.
After 2017.
But then it'll come before this.
2016, the law
The
came.
rules came.
And the rules came.
After.
At 2017, this writ petition was filed.
Yes, next. 14, 15, 16, same order.
At number 17.
Lord, I am appearing for the petition.
Petitioner?
Yes. What happened, my lord? This is second round of litigation.
Who is appearing for the respondents?
Notice was served. Who is
Mr. Devroy.
The last occasion he appeared. And my lord, last occasion he appeared, my lord, as per instruction given by my learned junior.
Mr. Devroy and Mr. Subroto Guha Biswas. He is also not there.
My lord, should I, my lord, place one thing, my lord?
In
After
absence
that,
of-
your lordship. What happened was second round of litigation. First round, death mutation application was pending. They did not consider estate manager, urban development. We came before this
Kalyani
on
property.
death mutation.
Kalyani
Kalyani,
property.
Kalyani. After that, there was a direction by this honorable court to consider. They rejected on the ground, first consideration, that 9C, your lordship knows that construction was not completed. Their prayer was that plot has not been handed over to you. So plan cannot be sanctioned, nor you have sent the draft lease deed, whatever it may be. After that, now, since they rejected the prayer, after that again we came before lordship. In the meantime, what they did, the plot resumed. Well, a statutory provision, your lordship knows, when both the parties came there to rectify the breach, that should have been given. That has not been given. We came before this honorable court, my lord, in the year 2018, sorry, my lord, extremely sorry. And thereafter, what happened, my lord, one of the petitioner, my lord, died. And my lord, if your lordship take note of order 22, then there should have been a time limit.
Yes.
My lord, I have filed the application. Since it was not within the knowledge of the wife and daughter, they have filed this application. Other petitioners are also there. My lord, may I pray for that? I will file one application giving the reason, what was the reason of delay in filing this application. Unless your lordship, he will be abated, my lord. His claim will be abated, my lord. Ranajit Kaur. One petition.
Petition number 1.
Petition number 1 in the writ application. And this is application pending for your lordship for substitution. But the reason of delay has not been given, my lord.
So you want to file another application?
Yes,
explaining the
that requires, my lord, for consideration by your lordship. If it is satisfactory, then your lordship will kindly allow them, means the wife and the daughter, my lord.
So please do that.
Yes,
And
yes.
please serve a copy to the.
Yes, that I will do. That I will do. Can 1 of 22.
This is a substitution application.
The substitution application. But the reason and
Delay
the,
of how many days?
my lord,
Delay of how many days?
my lord, 3 years. 3 years in the meantime, a pandemic was going, my lord. Your lordship knows, my lord, everything your lordship knows, my lord.
Are
See,
you
did
covered
not.
by the Supreme Court judgment on pandemic?
Because in the,
litigation part.
no, my lord, what happens, my lord? In the month of June 2019, in the month of June, he died.
June 19 he died.
I actually, my lord, the widow,
It has abated actually.
she is widow. She didn't know that the application is pending and her husband expired, my lord. When she contacted,
You have to in fact file an application for setting aside of abatement.
that's right. Giving the reason why, what was the reason why I could not?
So let me do one thing. Let me just adjourn the matter today without mentioning anything. Please file an application.
Yes.
Praying for
The
setting aside
liberty,
the-
my lord, at least kindly.
Not necessary. Since it has abated, you can file an application under the law.
My lord.
The court says so.
Yes. Your lordship, kindly
And
fix a
please
date.
serve a copy in the
I
meantime.
will, yes,
Yes, and
everything
fix a
I will
date.
do.
Yes. Oh, Ishagaj. On prayer of the petitioners, the matter is adjourned.
I'm state respond.
There is
Yes,
a question
substitution
of,
application is here.
there is a question of abatement.
Yes.
So the petitioners want to come back, filing an application explaining the delay
Yes.
and asking for setting aside the abatement. Yes. This is not a plain and simple
Yes.
substitution application. Let the matter appear under the same heading on 9th January.
My lord.
9th January, you'll be
Ma'am,
ready. You'll be
ma'am.
ready by then.
In the
Please serve
meantime,
a-
I will do everything.
please serve a copy.
Yes, yes. Hey, sir, thought, sir, at this.
চলো
বলেছিলাম
নামটা
দিদিকে গিয়ে বলেছিলাম ম্যাম
কোনটা? কোন matter?
Yesterday, she had come to submit in person. You have been appointed by the legal aid.
Yes, my lord.
You are appointed by the legal aid.
No, I have not been. I was under the impression perhaps in this matter she is making any submission.
No, she is making a submission in this matter, no?
No, I am not in this matter.
কোন মামলায় আপনি?
কোন মামলা জানেন?
কোন মামলা?
আজকে উকিল দিদিকে নিয়ে আসতে বলেছিলেন আপনি
She has a learned counsel, so I had refused to hear her
It is
first.
completely a different matter, Lordship. In this matter, Rubita Ghosh and Saswati Ghosh are the petitioners. And
Her
no.
instruction is that as per your lordship's directions, she intimated the learned advocate appearing on her behalf, and it was the instruction of the learned advocate that without intimating me, you directly went to the honorable court.
I also said the same thing to her yesterday. She had come directly to move before the court. I had asked her to contact her learned advocate.
চেষ্টা করবো না আমি ছেড়ে দিব রিট মামলা
She has been,
কোনো অ্যাডভোকেট ধরুন যখন আসবেন না,
আমার পয়সা খরচ করে
let her approach the legal aid committee, High Court.
আপনি লিগাল এড কমিটিতে যান, ওখানে গিয়ে দেখবেন কোনো অ্যাডভোকেটকে ওরা দিয়ে দেবে আপনার সাহায্য করা, হেল্প করা।
She has already been given a learned
Yes,
counsel.
that's right.
Maybe the learned counsel is not doing.
See, my lord, to be very frank, she got annoyed that without intimating me, you went to the directly honorable court. You should have intimated. This is the crux, I think. This is
Whatever may have happened.
my lord.
If the learned counsel, if she is not happy, let her approach the legal aid
আপনি
the
লিগাল এডে
committee.
গিয়ে আবার
They'll change counsel for her.
Yes,
ওরা তো বলছেন এখন দুদিন পরে আসুন
দুদিন পরে যান।
একটু সাহায্য করুন না ম্যাম অনেকদিন ধরে ঘুরছি এইভাবে
It's difficult.
That is different matter.
একটু সাহায্য করুন না, আপনি একটু সাহায্য করুন, চেষ্টা করুন।
আপনি আজকেই লিগাল এড কাউন্সিল যান, লিগাল এড কমিটির কাছে যান। কোথায় গিয়েছিলেন?
ওই লিগাল কমিটিতে
হ্যাঁ।
বলছেন যদি পরে আসবেন, এই করে তো অনেক দেরি হয়ে যাচ্ছে। এপ্রিলের কেস এটা, আজকে এখনো ওঠেনি।
দুদিন পর একটু ওয়েট করে যান, ওখানে দুদিনে কিছু তো হবে না। এখানে কোনো অ্যাডভোকেট থাকলে এসে এখানে জজ সাহেবকে বলবে আপনার কাছে।
সাহায্য করুন, অনেক
I would request one of you to help her out.
My lord,
Will you please, young
Lordship,
man, please help her out.
Lordship, I'm doing this. I'm doing this. আপনি আমার petition-টা একটু দিন, আমি এটা দেখে আমি করে দিচ্ছি। আপনি আমাকে দিন, আমি বাইরে চলুন, আমি করে দিচ্ছি।
Please help her out.
9 January, 9
16 তারিখ? হ্যাঁ, আমি বললাম 9 জানুয়ারি।
আপনি ওনার সাথে কথা বলুন, উনি আপনাকে সাহায্য করবেন। Yes, next matter.
Number 18. Lord, item number 18 to 22, my lord.
Yes.
Mr. Ujjal Rai is appearing on behalf of the petitioners, my lord. Is humbly praying, my lord.
My
this
lord,
matter
I
be
am
taken up
for the
after this
respondent.
vacation, my
I am
lord.
led by Mr. Dheeraj Trivedi. Kindly see the conduct of the petitioner, your lordship, from since February 2023. They are taking only time.
Actually, I was about to say this, several adjournments. I'll not know further adjournment. If you're not interested, let me drop the matter.
No, no, my lord.
Let me dismiss the matter.
No, my lord.
Oh, last chance has been granted. No further adjournment. Please make your submission. Otherwise,
Kindly grants not today only, my lord.
Yes.
Only grants not today, my lord.
Not today.
Yes, sir.
Tomorrow they'll all be dismissed. Not
Wait
today, Guru. 19 to 22.
22, my lord. 18 to 22, my lord.
22.
Yes.
Not today only. Next.
Item number 23. My lord, item number 23, 24, 25, and 26 are identical. My lord knows the petitioner completed his submission, and then I started my submission.
Mr. Pulok Ranjan Mandal is appearing for the petitioner.
Yes.
His Pulok Ranjan Mandal is appearing for the petitioner. He is suffering from fever. His clerk informed me.
Maintenance is not a challenge.
Yes, that suppression, my lord may recall, kindly recall, I cited
Yes.
that he himself appeared in the matters he has suppressed in this proceeding.
Yes, yes.
And there are other points also, my lord. I just started on the last occasion. So, my lord, on the personal ground, my lord, certainly, my lord, I will not be opposing today. My lord grants them time.
January.
But no, kindly do not. Then, my lord, we are in the midst of hearing.
There is no interim order.
There is no interim order. He has completed
The
his
matters are in
submission.
the midst of hearing, Mr. Talukar. This we don't even have three.
Can it be on next Tuesday?
No, there
Will
are
you-
other
then-
other matters pending. There are a lot.
That's
of
the
matters
difficulty. It is, my lord, I must say, my lord, it may be also is trying to
But since there is no interim order, come back in January. Come back in
just it's a but, my lord, to avoid this court. Kindly do not allow this. This side of vacation.
How far can it be avoided, Mr. Talukar? 1 day, 2 days, 3 days after that?
No, why I am saying so, my lord? He has completed his submission, and I have started. I'm prepared.
Learned Council had submitted on merits.
Yes.
After that, you challenged the maintainability, alleging suppression of facts. I remember. Come back in January. These 3
January.
weeks, there are several matters pending.
That's true, my lord.
Mr. Talukar, I sit with a list of, I think, 500 or 600 matters. So it's difficult.
Often I also pray for that, not that.
On prayer of the, please be ready on the next occasion. No further adjournment. On prayer of the petitioner, the matter is adjourned. Paragraph, let the matter appear under the same heading on 16 January
16.
2024.
Up to 26.
23 থেকে 24
Up
কিন্তু
to
আমরা 23
26.
তে নামটা দিলাম। আর এই দেখো 25 আর 24 বোধহয় আগে অর্ডারে ছিলাম আমরা না।
কবে আসবে রাজিন্দা?
এই নামটা দাও
16 জানুয়ারি।
তোমার নামটা দাও 16 জানুয়ারি।
রাজীব যে নেই তার নাম দেবেন না, একটু অন্যদেরও বলে, বাকি তিনজনকে বলে। Yes, next.
আপনার নামটা দিন, আপনার নাম। Up to 26.
Up to 26, same order. 27 টা।
Number 27.
Yes, 27. Petitioner. 27, petitioner. No one. 27, petitioner. Dismiss for default. Let me start dismissing. Rajiv, dismiss for default. Several occasions.
Number
It's wrong
28.
with the lesser attendance.
Madam, 28 I am for the private respondent, madam.
Yes,
28, madam.
I'll just call.
And I am led by Mr. Monishin.
Item number 28, I am for the petitioner.
Yes.
The advocate in court, Mr. Pathapradeep sir, is engaged in another court. He told me to pray for not to them, my lord.
Madam, mainly this matter has been infructuous because we are the beneficiary, my lord. We are the main respondents, my lord, in this case. But we have received the amount already, my lord, for which the case was made.
Please, my lord, I pray not to them. Keep it on tomorrow. My
Make it not today.
My lord, instead of not tomorrow, any day, my lord, some difficulties, lordship, for tomorrow, lord, I have some difficulties. But the amount has already been deposited, my lord. The amount has already been deposited and the private.
Yes, my lord, we have received the amount.
Yes, my lord.
Yes, my lord, the
My
matter has become
understanding of
infructuous.
this case, my lord, matter has become infructuous.
Yes, my lord, that is the same submission. My lord, it was our land, my lord. It was taken away, and my lord, we have received half compensation, and later on, the half was compensated. So we have received the entire amount, my lord. So we are the beneficiary, my lord. We are the main respondents, my lord.
This memo which is under challenge has been given effect to already.
Yes, my lord.
My lord. The memo dated 31st October 2019.
My lord, here the state lordship, they are the disbursing authorities, my lord, they should make their submissions regarding the disbursement, my lord. But our parties, lordship, have already deposited.
Yes, my lord, and we have received
And
it as well.
private
And
authorities,
Yes, my lord. Yes, my lord.
My lord, on what basis, my lord, they
We will come back on Friday.
next week, my lord, any day next week, my lord.
My lord, Tuesday, make it Tuesday, my lord. Kindly.
Tuesday is 12th December, next Tuesday. Please be ready, sir, on the next occasion.
Okay, madam.
16th.
Prayer of the petitioners, the matter is adjourned. Paragraph, let the matter appear under the same heading on 12th December.
12th.
আপনার নামটা দেবে না, আপনার নাম
মঙ্গল।
আমার নামটা আচ্ছা, আমার থার্ড নামটা উপরের নামগুলো কেটে দেবো। আমি কিন্তু জুনিয়র, সিনিয়র না।
Number 29.
Actually, junior.
For the petitioner, my lord.
Advocate on record না হলে নেবেন না। Advocate on record হতে হবে।
Item number 29, I am for the petitioner, my lord.
Yes.
In the earlier order, your lordship has passed an order to allow us, the petitioner, to allow us to file an amended writ petition, my lord. Your lordship may recall that for my personal difficulty, I could not make ready, my lord. Yet to be affirmed. Kindly fix it on coming week on 12th May, on 12th December, my lord.
After vacation.
Actually, in the meantime, I shall forward a copy of the amended writ petition to the other side, my lord.
On prayer of the petitioner, the matter is adjourned. Paragraph, let the matter appear under the same heading on 11 January.
No, my lord, kindly tell December, my lord. I'm ready.
All matters cannot be
Make
fixed on. I have
complete ready, my
several
lord.
matters, no?
It will be a long gap, my lord. Kindly allow me.
We don't have, we have only 2 weeks. Please come back.
Kindly allow me. Only coming day, 12th December, I shall make ready.
I said
Yet to be about.
11 January, sir. Next matter.
January.
Deeply obey.
11th January.
জানুয়ারিটা বড্ড দেরি হয়ে গেল
Item number 30.
30 million, I am appearing on behalf of the state respondent.
Behalf of the petitioner, my lord. My lord, currently I am the present AOR, but I have not received the Vakalatnama yet. My lord, if you may kindly fix this matter on Friday, then I will file the.
Have you seen the conduct of your client in the earlier occasions?
Actually, my lord, a letter has been addressed to the erstwhile AOR, wherein he has instructed us to withdraw the matter. But
Yes.
as the erstwhile AOR is not in presently here, so I have received an NOC and I have sent the same to the client to sign and give me power.
My lord,
I
I
will-
have received this letter which they want to know, not to proceed this matter,
Yes,
my
my
lord.
lord. I have received the same, but currently I don't hold the Vakalatnama. Just give me time until Friday and I will.
Come back on Friday, you want to withdraw the matter?
Yes, my lord.
Yes, my lord.
Friday.
I will file a fresh Vakalatnama and I will withdraw the
On
matter.
prayer of the. So let it appear as to be mentioned on Friday.
To be mentioned, my lord.
On prayer of the petitioner, the matter is adjourned. Paragraph, let the matter appear under the heading to be mentioned on 8th December. You have no locus to submit today, so.
Yes, my lord. I have just received the brief yesterday.
So let me record none appears for the petitioner. I'll fix it on Friday. Take necessary steps in the meantime, please. Rajiv, none appears for the petitioner.
I am appearing, my lord, on behalf of state.
Next.
Friday.
Item number 31.
31, I am led by Mr. Devasis Banerjee, behalf of the petitioner, my lord. Kindly short time for file exception, my lord. State file, state report.
State.
Mr. Owen Banerjee is appearing for the state respondents. Report was filed before.
Yes. Petitioner is not in a hurry.
The report was filed, my lord, as per your direction.
Supposed to file an exception.
Yes, one exception has to be filed.
Learned counsel for the petitioners seeks further extension of time to use the exception as sought. Paragraph, let the matter appear under the same heading on 17th January.
Deeply obey.
Mention.
Mention it.
Mention matter item number 487.
Lord, I beg to appear for the petitioner, my lord.
Respondents.
Mr. Bandyopadhyay is appearing. Yes, ma'am. Mr. Bandyopadhyay is appearing. Both no, এটা 487. কেন রকম করছে?
Have you served the Panchayat Samiti?
Yes, my lord. My lord, may I, what happened here?
My lord, but kindly take it up tomorrow or the hour.
My lord, the land of the petitioner was utilized by the respondent authority, my lord, without following due process of law. Then, my lord, I filed a writ petition, your lordship, in the first round of litigation, directed the BLRO to inquire into the matter. BLRO inquired and found that 1.32 acre of my land has been utilized for public purpose and sent the report to the land acquisition collector. But no step was taken. I proceeded with the second round of litigation. Your lordship, in the second round of litigation, directed the land acquisition collector to take a decision, my lord. Accordingly, the DM, my lord, took a decision and admitted that no acquisition proceeding was done, but my lord, he rejected for payment of compensation. This is under challenge here in this writ petition.
When there is no acquisition, there cannot be compensation. They have to either directly purchase or initiate a fresh proceeding.
Nothing has been done, but forcefully, my lord, government cannot utilize my land when admittedly BLRO has submitted a report that 1.32 acre land, my lord, that has been utilized by government.
I think Mr. Bandyopadhyay needs to take instructions in this matter. Also.
Yes, my lord.
So instead of wasting time, please come back with the instructions.
ইউটিলাইজ করেছে কারা
ওখানে হচ্ছে কমিউনিটি ট্যাঙ্ক তৈরি করেছে
আরে কারা সেটা
পঞ্চায়েত
পঞ্চায়েত
সমিতি।
পঞ্চায়েতে হলে আমরা করতে পারবো না আমার কোনো গল্পই নেই স্টেট করতে পারবো না পঞ্চায়েতকেই তোমাকে করতে হবে
পঞ্চায়েতের পরিচিত পার্টি
তো পঞ্চায়েত এসে বলবে কারণ পঞ্চায়েতের সঙ্গে স্টেটের কোনো ব্যাপার নেই কারা করেছে সেটা জানতে চাই।
এটা কি আছে সেটা তো কমিউনিটি ট্যাঙ্কটা তৈরি করেছে হচ্ছে পঞ্চায়েত সমিতি।
But পঞ্চায়েত সমিতি মানে as a land fund মানে landed trade is the
But they
answer
are not appearing.
Yes, I have
পঞ্চায়েত
served.
সমিতি my lord
Served, sir.
পঞ্চায়েত সমিতি
Served, but they are
and
not
again he
appearing.
will submit government has not constructed the tank my lord not utilized the land পঞ্চায়েত সমিতি is a separate body.
No, is it recorded that the Panchayat Samiti has utilized
As per his my lord
in the order in June?
Yes, my lord. It has been recorded, my lord. Kindly see page 53.
Yes.
May I place it, my lord, for once? The second paragraph. So and so claimed that area of 2.551 acres of land in LR plot number so and so recorded in favor of LR Khotiar number so and so. As per his claim, in the year 2018, Simlipal Panchayat Samiti has excavated a community water tank in 1.32 acre of land in plot number so and so, and authority neither acquired the said land nor paid any compensation to him. Being aggrieved, moved before the Honorable High Court, Calcutta, filed WPA so and so. The Honorable Court has been pleased to pass an order dated so and so and directed the BLRO to take necessary measures for retrieval of the grievance. Then the BLRO has initiated the compliance proceedings. Past order, the BLRO opined that writ petitioner land in Rayati in nature and community tank was dug in portion of the writ petitioner's Rayati land measuring about 1.32 acres. Undersigned heard the submission of writ petitioner Rohit Mondal and also perused the necessary case records. Here it is to mention that Honorable High Court Calcutta has directed the undersigned to consider and dispose of the representation of the writ petitioner dated so and same should be done taking into consideration the order passed by the BLRO dated so and so. As per the representation of the writ petitioner, so this is found that Rohit Mondal has expressed that Panchayat Samiti authority has excavated community tank in plot number so and no compensation has been paid to him for such work. Again, the order passed by the BLRO Taldangra expressly mentioned that the petitioner land is Rayati in nature and community tank was dug in portion of the writ petitioner's Rayati land. In this regard, this is to mention that undersigned has gone through all land acquisition case records available.
That is all right. From the part of the additional district magistrate, he is not wrong. Since there is no acquisition proceeding, you are not entitled to compensation. But it is your submission that the Panchayat.
Yes, this is my knowledge. This was my knowledge.
From where do you get that knowledge? It is not observed by the authority. It is your submission.
Submission. That matter when I inquired, when the community tank was being excavated, I asked the persons who accepted.
Document?
A document.
Who appears for the Panchayat generally? Panchayat Samiti.
Well, the different Panchayat Samiti has a different lawyer. Oh. Well, as I learned from my class, my lord, it is not allotted to me.
Oh.
It is not. ভুল নাম দিয়েছে তোমাকে ভুল নাম দিয়েছে আমরা নেই আমাদের অ্যালট করে না আর যদি জজসাহেব বলেন তাহলে করতে হবে তোমাকে
Yes, I'll request you to appear. Yes.
My lord বললাম করব.
Yes.
Please serve a copy to Mr. Bandyopadhyay.
Yes, definitely.
I'll regularize his appointment.
Yes.
But the difficulty is there is not one line of observation that the Panchayat Samiti has done it. Otherwise, I could have directed the Panchayat Samiti to take necessary steps.
My lord,
will you please do one thing?
Well,
Will you please inquire as to who represents this Panchayat Samiti and inform the learned counsel? It will be better for the petitioner also if the learned counsel is present in court. Otherwise, if I dispose it of giving a direction, it may not be
complied with. But kindly,
and
my
they
lord.
may come and deny it. They may say that we have not done it.
My lord.
There should be some document to show that they are responsible for this excavation.
My lord, kindly see page 21. This is the work order issued to the contractor, my lord, who excavated this. Issued by the Simlipal Panchayat Samiti, page 21. My lord, subject work order of excavation of community tank, so and so, memorandum, so and so. With reference to the above, this is to inform you that 31 point below offered. Therefore, you are requested to start work immediately in consultation with and complete the same within 45 days.
Yes.
So this was done, my lord. One copy I have received from this Soikot Sinha Babu, my lord, who is the contractor. Now, earlier round of litigation, I made him as party respondent. And I have stated also, my lord, in my writ petition.
So please do one thing. Please try and serve a copy to inform the learned counsel at least.
Lord, I do not know who appears, my lord. Kindly direct me, my lord, to serve again to the Panchayat Samiti, my lord, and keep a fixed date, my lord.
Since
Otherwise,
service is made, please intimate the date. I'll
yes,
fix the
yes,
date,
yes,
Please intimate the date.
yes, yes. And also, my lord, I will communicate your lordship today's order, my lord, that
Yes,
your
yes.
lordship said. Yes.
Affidavit of service. None appears for the respondents despite service. Stated
Remember
notice
the copy.
about whether service liberalized করুন, copy
এটা
service
জেনে নিন।
direction.
Simlipal কোথায়?
Bankura.
Simlipal forest আছে না? এটা 400 সেই ঘটনার কপি।
হ্যাঁ, লিখুন দিয়ে দেবো, নিশ্চয়ই দিয়ে দেবো।
Paragraph learned counsel for the petitioner submits that his land has been utilized by the
আচ্ছা ওইটা বেশি করে ওটা আমি বের করবো আমার কাছেই থাকবে না পারলেও
Shimla Pal Panchayat Samiti,
আমার কাছে বের করাই তো আছে
being the 7th and 8th respondents herein, for excavation of a community water tank, but the land was neither acquired, nor any compensation paid to him. Stop.
ওর ডাকনাম চলছে
The order impugned, passed by the additional district magistrate within bracket land acquisition bracket closed, Bakura, on 14th March 2023, demonstrates that the plot in question is Rayati land. Stop. A work order issued by the Shimlapal Panchayat issued by the executive officer, Shimlapal Panchayat Samiti, to one Soikot Sinha Babu, on 23rd March 2018 for excavation of community tank in the plot in question, also indicates that the said work has been done by the seventh and eighth respondents. Paragraph, since the 7th and 8th respondents are not represented despite service, further notice, the petitioner is directed to issue further notice, serve further notice upon them, intimating the adjourned date. Paragraph, let the matter appear under the same heading on 5th January.
I'm grateful.
Well, the appearance of one.
Copy দিয়ে দেবো দাদা।
488. For the state respondents.
Petitioner 488. Mentioned matters, still they are not there. No one. Dismiss for default.
Dismiss for default. Dismiss for default. 489 for the petitioner.
Madam, Miss Manali Biswas is for the respondent number 8 and 10. She is not present in the court as her uncle died. So I request Lordship to kindly take the matter next week.
State is served.
Yes, ma'am. Last Friday, this matter appeared when the state was there, and I took time on the ground of the private respondent's advocate because there was mishap in her family. So one of the
Her uncle died. Lordship.
That was on the earlier application.
Next week she will be coming.
next week is only a few days are there.
She directed me to.
But I will be praying for constitution of my representation at page 20.
Can that be done? You are the advocate on record.
No, madam.
We keep it then Monday.
Next week.
All are served. 7 except only one private respondent. Malady says he is not available, but other 2 they have been served. I have checked up my affidavit of service.
We serve. No such
Person address. So I can't serve upon him. That
serve and come
because next 2, the rest 2 they have been served, my lord.
There
are 3
separate people.
Yes, 3 separate people. But my lord, in respect
You
of
either delete his name or serve. Any one of these.
no, kindly allow me to delete. Kindly allow me to delete.
9.
9.
Let me wait for till the next date. I'll do that on the next day.
Yes, ma'am.
Affidavit of service. Paragraph none appears for the private respondents. None appears for the respondents. Mr. Dey, may I request you to appear because state has been served.
Lord, Mr. HON'BLE is appearing in this matter.
Oh, I'm sorry. Yes.
He's engaged in courtroom number 6 before their lordships.
Come back on Monday. None appears for the private respondents. On prayer of the state respondents, the matter is adjourned. Paragraph, let the matter appear under the same heading on 11 December.
Yes.
Short matter can be disposed of.
Number 490.
Anyone for the petitioner?
I am for the state, my lord. Don't case is sitting here, was sitting here, my lord.
No one for the petitioner? Mentioned matters, I'll dismiss them. They mention it as very urgent and then they don't turn up.
That is not mentionable here, my lord, because at the correction of the court of prayer, if your lordship will see the prayer. Page 16.
Correct the record of rights.
Yes, ma'am. What are the questions?
Let me pass an order. None appears for the petitioner. No accommodation is sought. Paragraph, the matter pertains to the West Bengal Land Reforms Act 1955. Paragraph. Let it be dismissed for default because otherwise an opportunity can be given.
Or not today, my
Otherwise, I have to.
I can't hold it.
Not today, রাখুন তো। কেটে দিন। Let it be not today. Let us see tomorrow.
Yes, ma'am.
What is wrong with the attendance is very.
You are sitting here. When the matter is.
Everyone has gone to the film festival. Next.
I don't know, 491.
My lord, I beg to appear on behalf of the petitioner in this matter, my lord.
Lord, Mr. Hon'BLE is appearing as per the list which I got from the clerk, my lord, but the advocate for the petitioner is, has said that somebody else is appearing. I'm not sure, my lord.
Yeah, hearing.
What does that mean?
I did not understand.
Mr. Banerjee, you're appearing in the film.
I'm appearing.
My lord, may I proceed?
Who is this someone else?
Yes, I do not understand. But
Carry on.
yes, my lord. My lord, the land in question was under the predecessor in the interest of the petitioners, and by passage of time, my lord, the petitioners are the absolute owners of that property. They started cultivating and staying in that property. My lord, suddenly they came to learn that the predecessor interest that it is a vested land. Now a civil suit was preferred by the predecessor interest of the petitioners. 2 rounds. First round, the learned civil court allowed the application by the predecessor of interest of the petitioner that it is not a vested land, it belongs to my forefathers. Now it went up to the appeal by the state authorities. There also the order was sustained, and it held that my predecessor interests are the owners of the property. Now, my lord, everything was fine. We have been enjoying the property throughout. Suddenly, my lord, a notice was issued upon us on 30th of May 2023 at page 50 under the West Bengal Public Land Eviction of Unauthorized Occupants rules, targeting us as the unauthorized occupants, and we were directed to vacate the land. My lord, as I have taken records of the orders of the civil courts, I have already annexed these orders with the decrees that it belongs to us. If your lordship so pleases, I can place before your lordship. Now, my lord, what happened? A hearing was conducted in page 51 in 3 days, my lord. In 2 days we appeared, but it recorded that it has been passed ex parte. Now, my lord, before my lord going to the order, my lord, this order we challenged before the appellate authority. After becoming aware that such a drastic order has been passed, and my lord, on 8th of September, bulldozer was placed over there. Few portion has been bulldozed. Construction has been started building. Even though by order of the learned civil court, we are the owners of that property, the state authorities did not take into consideration. Now I place before your lordship.
The deeds before the state authority, the
Lordship?
judgments. You place the judgments before the authority.
He submitted, despite that it says that you have not appeared. Now, my lord, we preferred an appeal. Appeal is pending for the timing. Now, my lord, I have come for a very limited scope before your lordship, because, my lord, the appeal is pending. The merit will be decided before the appellate authority. It has been pending since 6th of November 2023. No step has been taken. Meanwhile, the urgency is that they have started bulldozing the property and started construction. My lord, my humble prayer today is that, my lord, kindly protect us for the timing till the appeal is heard out. Otherwise, I cannot make any other prayer before your lordship, because the merit will be decided, my lord. With all fairness, I submit, my lord. It will be decided whether I'm entitled or not upon considering all the records before the appellate authority. Appellate authority will decide the issue. Till then, my lord, let nothing be done for that short period. Kindly a short period may be fixed.
Let him show that he has made a prayer before the appellate authority for stay of the proceeding, and it has been rejected. He will have to show.
No, it is pending before the authority.
No, prayer for stay of the order. He has to.
If there is no stay,
It is the merit.
Can this be done?
I mean, if they don't ask for stay of the proceeding, my lord.
We have not asked. Let's take it.
Because I don't have the order sheet of the whether they are delaying the appeal or not.
No.
At the instance of
it has not been initiated. I have stated it is not. We have prayed for setting aside of the order. Expedite this matter within a short period. Till then, nothing be done. Yes.
Within?
Then no coercive action.
Within, my lord?
1 month.
1 month.
Yes, no problem.
Affidavit of service. The petitioners claim to be the recorded owners of the plot in question, as also declared by the civil court. The petitioners received a notice under the West Bengal Public Land within bracket eviction of unauthorized occupants bracket closed rules from the subdivisional magistrate, Islampur, Uttar Dinajpur, on 30th May 2023, directing them to show cause as to why an order under section 4(1) within bracket 1 small a of the Act of 1962 shall not be passed against them. Stop. Though the petitioners claim to have appeared before the authority for the hearing, the order impugned passed on 31st August 2023 records that the order was passed ex parte since the petitioners herein failed to submit documents with regard to their claim. The petitioners have carried the said order in appeal, which is pending. Paragraph, learned counsel for the petitioner submits that during pendency of the appeal, the state authorities have demolished structures.
And they have already entered and started constructing over there.
Some of the structures in the petitioner's /apostrophe land and have started raising construction therein. Paragraph. Upon consideration of the submission made on behalf of the parties, this court is inclined to hold that since the petitioners have preferred an appeal against the order impugned, which is pending, the concerned authority, who is the appellate authority?
My lord,
Respondent
district magistrate,
Second
district magistrate.
Kindly record note the allegations made by the petitioner are all denied by the respondent.
Learned counsel for the respondents denies and disputes the allegations made by the petitioners. তারপরে এটা আসবে upon consideration of the submission তারপর
Respondent 2 to appellate authority.
Being the second respondent herein, be directed to consider and dispose of the appeal within 1 month from the date of communication of this order, upon affording reasonable opportunity of hearing
And considering all records, my lord.
to both the parties therein, and considering the documents placed by the parties, in accordance with law.
My lord, great.
Paragraph, pending disposal of the appeal, the order impugned,
Yes.
dated 31st August 2023 is stayed.
Grateful to lordship.
Pending disposal.
1 month.
Disposed of?
Till the disposal of the appeal. Well, a reasoned order may be
Petitioner
passed.
shall communicate this order within a period of 7 days, because if
Yes,
they don't,
we have to. We have to.
kindly record that. Otherwise, if
Yeah,
they,
we have to do
because
it.
it is 1 month. I'm appearing still.
My lord,
let the petitioner communicate.
my lord, a reasoned order may be passed and supplied to us as well in the appellate authority. That otherwise we do not know. They will come and say it has already been done.
Copy of the order be communicated to the petitioner within a week thereof. তারপরে pending disposal of the appeal, stayed হবে. Disposed of a chattel.
Grateful, extremely grateful.
At number 32.
Could I appear for the writ petitioner?
Yes.
Well, I appear for the proposed added respondent. The writ petition was, I have made an application.
This writ petition is was disposed of by your lordship. Thereafter, my learned friend challenge that before the appeal court. Will
Yes.
kindly take up the application of my learned friend.
You were granted liberty by the appellate.
I was
court.
granted liberty by the
Forum?
appellate forum to make an application for addition of party. I have made an application for addition of party. To that, they have filed an opposition. The writ petitioner has filed an opposition. annexing
Everything
the
is, my lord,
entire document of the office which we are not aware of. My lord, we want to use it or reply to that. Because our case is that, my lord, we are in possession of the bill for with a lease of 99 years. My lord, in the meantime, there is a derequisition proceeding. My lord, the writ petitioner, some of the writ petitioners approached before this court several times without making us a party, sometimes making us a party, or sometimes without making us a party. That and suppressing all those material facts in there, they have moved this writ petition and obtained an order from your lordship, my lord.
You
We
will
have
come back with an affidavit in reply?
yes.
my lord,
Bandapati, you have received a copy of the application.
So you have received money.
Do you also want to come back with an opposition? Not necessary.
I can come with a report, man.
Kindly see, they are saying we suppress the fact.
Yes, yes.
They are saying, kindly see,
Let him come back with an affidavit in reply.
one submission, my lord, kindly see. The order passed, derequisition order was passed by the authority concerned, that is in application, kindly see, my lord, the applications. Page 21. That is the order.
Page 21 of the application or the writ petition.
Application. Everything is here.
Own application.
Can 1.
Can one, yes. Page 21 is part of the order, yes.
The order dated 12 February 2020.
Page 21 is paragraph 12 of the application.
নেই তো
কি দেখাচ্ছে ওটা?
My opposition, sorry, my lord, my opposition. My opposition.
আমরা তো আমরা তো রিপ্লাই দেব না।
This is the derequisition order.
Derequisition order. Next page, my lord, kindly see. Page 20.
There was an order by this court
Paragraph
granting
3.
liberty to the authority to derequisition it and my lord,
Let me
initiate
complete.
a
Let me
fresh
complete first.
proceeding.
Complete.
Lord, kindly see. Serial number 3. DLRO Nodia with the request to deliver the possession of the land free from all encumbrances in favor of the present owner. They are not the owner. They are claiming they took lease.
You are on merit, sir. He wants to come back with an affidavit in reply.
But the things is, the basic things is the possession should be delivered to the owner.
Basic
Let
thing
him
is
come back
where
with
the
his
land must be.
affidavit.
As your lordship,
Because
but
this
things
is-
is, they are not the
This is
owner.
your opposition. Learned Council wants to reply to this. Let him come back.
Their application, they have annexed everything.
I repeat, sir, you are again on merits.
As
He
you.
has to be given an opportunity because you filed an objection.
Lord, I have filed the
opposition থেকে
opposition.
রিপ্লাই দেবে
So he has to file a reply to it.
As your lordship.
আমরা
Learned Council for the proposed intervenor seeks to use an affidavit in reply. The affidavit in opposition submitted on behalf of the petitioners.
আমাদের
Paragraph, let the matter appear under the same heading on
আমি তোমার রিটে তুমি ছিলে না
15th January.
না না
15th January.
15 January.
Please serve an advance copy in the meantime.
Lord, matter may be fixed, my lord.
15 January বলেছে
15 January.
তাহলে একটা কপি দিয়ে দিচ্ছি।
রিটেল কপি দাও
রিটেল কপি তো কি করে রিটেল দেওয়া হয়েছে
নেই
নাম্বার 33
শুভব্রত নারী
তো শুভব্রত জানলা তো হবে না
তাতে কি হবে আমাকে রিটেল করে দিতে
বলে
হবে
কপি অফ দ্য রিট পিটিশন বি সলভড আপন মাই লর্ড আদারওয়াইজ মাই লর্ড ইট ইজ
dispose of read, my lord, it is what before the state.
Once it is disposed of, it is sent back to the government.
Copy, my lord, I have
Please serve a copy.
ভালো হবে আদার অন্য সেট অফ লয়ার ছিল না দিলে আমি করব
After disposal, it is resubmitted.
as you
Please serve a copy.
I shall serve.
My application. Lordship, today is the day for filing the report, but an advocate for the respondent is
Mr. Ganguly is appearing. Mr. Oshim Ganguly.
my lord, for last 4 years, I am my lord, debarred from carrying out my mining activity. My lord, he is not here. The report has not, the copy has also not been given to me. My lord, only one thing is owing, my lord, as a matter of concern. Lordship kindly appreciate. My lord, this plot was handed over to me on 12th of February 2019. So according to your lordship's judgment, what your lordship has already held that the starting date of mining, my lord, is the date of possession. So my lord, it will be expiring on, that's why I mentioned this matter also, it expiring in 12th of February 2024. Before that, my lord, they put the option out ordinarily. But I am only, my lord, till the writ application decided, I'm only playing for a very, my lord, limited interim order, my lord. That is this prayer F. Lordship, kindly see page 24. He is not here. The report is not given, my lord. This is pending. I will not. I will be debarred from, my lord, challenging the act of the respondent authority. Lord, let no auction be held in respect of this plot. If it is held, my lord, if any third party interest is created, my lord, I will be in other trouble, my lord.
Very well, then let there be no third party interest.
My lord,
No third party interest be
my lord,
created.
that prayer F may be granted.
None appears for the state respondents. Stop, no report is also filed. Paragraph, let the matter. Yes. The state wanted to file a report, and what has happened to Mr. Ganguly? He's not well or something. He's not appearing in any of the matters.
Today he was in the court. I've seen him.
He was in court?
Yes, my lord. My clerk will
Yes.
instruct.
Let there be an interim order not to create any third party interest. Because no report, state is not being represented. It cannot go on like this.
And my lord, in this matter, 3 times the hearing was held. No order. My lord,
First of all, my lord, I don't know, my lord, whether the West Bengal trading.
they have no role to play because,
Been sought, my lord.
2016
My lord, I don't
auctions,
know.
my lord, they have come into
you
play.
served?
Yes, my lord.
Very
The evidence service is there, my lord. Yes, yes.
Because my lord, no brief is with me, my lord.
That I can supply the copy, but lordship, the copy has been served. My lord, I'm trying to point.
Yes, it is served. Mineral development has been served.
And since my lord is passing an interim order, my lord, my lord.
Because the state wanted to come back. Today, the state has not cared to be present also. So let there be an interim order. Why should the petitioner suffer? None appears for the state respondents. No report is also filed. Paragraph, let the matter appear under the same heading on 18 January 2024. Paragraph.
My lord, may I just pray one thing, my lord, since my the 2021 rules has come, my lord. My lord, may I just check with my clients that whether in third party.
Till the adjourned date, I'll pass an interim order.
Only till date.
Till the adjourned date, then come back. Yes. The respondents are directed. Respondents are restrained from creating any third party interest in respect of the plots in question till the adjourned date.
Till my lord, few days later, my lord, because if
Let
the
them come
18th,
back.
if the 18th matter
Let
is
them
not
come back, I'll deal with it on the next.
till 19th, at least, my lord, because if the 18th the matter is not taken up, my lord, the interim order, because they can, my lord, the auction can be published on any day, my lord, till 19th at least.
If it is not taken up, it will automatically be taken up on 9th.
The interim order till 19th, I was praying.
No.
I'm grateful.
Number 34. 34, my lord, I am for the petition.
Yes, service complete.
Yes. And also,
Who is appearing for the state?
I have also served upon the learned government leader. Here is
Mr. De, may I request you to appear?
This matter,
Have a copy to Mr.
this matter relates to unauthorized enforcement. The petitioner lodged complaint.
PWD land.
Yes, ma'am. On the basis of complaint, the assistant engineer wrote a letter to the block land and land reforms officer to demarcate the land, but that has not yet been done. Lord, kindly come to page 24. Page 23, 24.
This has not been done.
This has not been.
Let there be a direction. Where is your representation?
That is at page 18. And petitioner's representation as page 15. Annexure 3.2. Page 15.
Affidavit of service. None appears for the private respondents despite service. Paragraph. The petitioner claims to be the recorded owner of the plot in question and complains that the private respondents have raised unauthorized construction by encroaching upon PWD land adjoining their property, comma, thereby obstructing adjoining his property. His property, thereby obstructing his egress and ingress. The petitioner submitted a representation in this regard before the concerned authority 23rd December 2021 and prays for a direction upon the authority to consider the representation at the earliest. Paragraph. Learned counsel.
No, my lord. In response to the said representation, wrote a letter to the assistant engineer. That is at page 23. To the block land and land reforms officer, Nodia.
Yes, I'll state that. Learned counsel for the petitioner has taken this court to letters issued by the assistant engineer, comma PWD, comma Krishnanagar subdivision to the block land and land reforms officer on 22nd February 2022 and 4th March 2022 respectively, comma, in response to the representation submitted by the petitioner, comma, requesting the block land and land reforms officer to demarcate the plot in dispute in order to ascertain whether the said plot belongs to the government. Stop. It appears that the demarcation is yet to be made. Paragraph. Learned counsel for the state respondents submits. Recommends they regularize appointment regularize. Nana, yes. Yes, yes. এটা দরকার নেই সাবমিশন none appears for the respondents করুন private respondents না করে মিস্টারদের appointment regularize করুন আচ্ছা upon consideration of the submission made on behalf of the parties comma this court is inclined to hold that since the assistant engineer comma being the fourth respondent herein comma has written to the block land and land reforms officer comma being the fifth respondent herein for demarcation of the plot in dispute, comma, such demarcation should be completed by the fifth respondent and report submitted before the fourth respondent within 1 month from date. Stop. Upon receipt of such report, comma, in the event such demarcation be completed যেখানে বললাম না বলুন জায়গাটা fourth respondent upon by the fifth respondent upon service of notice to all concerned, including the petitioner and the private respondents. And report be submitted, right? Within 1 month. In the event encroachment upon PWD land or any portion thereof is found, the fourth respondent is directed to initiate proceedings under Section 10 of the West Bengal Highways Act 1964 and take the proceedings to its logical conclusion within 2 months. Within 2 months from the date of receipt of the demarcation report, upon affording reasonable opportunity of hearing to all the interested persons, including the petitioner and the private respondents, in accordance with law. Please prove that.
Number 35.
I'm for WB HITCO, my lord.
State, Mr. Bandyopadhyay.
This is a similar thing, prior formal demarcation. Things for a moment. Lord, the land has been acquired and handed over to the HITCO. Now the HITCO, my lord, my land, priority land has been enclosed and started the construction. That allegation is made. Earlier occasion I come before this honorable court. The honorable court passed an order to demarcate inquiry. Lord, that inquiry was not done. Physical inquiry is not done. But the only paperwork has been issued. Lord, the paragraph 12, 13, I categorically stated. Paragraph 12, 13. No physical demarcation has been held. And my lord, the report has been filed in such a way, I draw your lordship's attention, report.
The report of the state.
A report of the state. I also filed the exception. So the kindly see paragraph 5. Report. Entire land is, my lord, the 1.42 acres. Out of some portion has been acquired. My plot is Rayati plot 139. 139 plot is a big plot. Only portion of the land has been acquired. Lord, no physical demarcation has been held at yet. My prayer is only similar prayer also earlier considered by your lordships, annexure P6. A lordships passed an order, another matter. I prayed for similar order should be done. Annexure P page 68. Only prayer for demarcation in the set, unlisted demarcation, no construction carried out. Since the acquisition proceeding has not been challenged, the representation has made by annexure P7. Representation made annexure P7 that has not been considered. In the representation also, my lord, the categorically stated that the no physical demarcation has been made.
Yes, Mr. Bandyopadhyay.
Well, it is not that case, my lord, which my learned friend is submitting before your lordship. My petitioner purchased the land from one Kasinath Naik. Kasinath Naik, my lord, moved the writ petition before this honorable court, alleging that the HITCO is encroaching the land of the Kasinath. And that matter has been disposed of by this honorable court, directing the authority concerned to demarcate. That is annexure P5, which my London is showing. Kasinath Naik. That has been disposed of in the year 2017. And thereafter he has purchased the land. Now he has come with the plea that his land is encroaching. Already demarcation has already been held.
This is a 2022 order.
Which one,
Annexure
madam?
P6.
This is in any another case.
Another
It's another.
in the same-
Your lordship has been pleased to dispose of the matter.
Yes.
We have demarcated that land, my lord. That in respect of the duty on the same allegation.
No, my lord, here is the page.
No, no, here the petitioner is not the party.
No, no, that is not the case. We prayed for similar order.
Similar order.
Prayed for similar order.
In this case, my lord, the land has already been demarcated.
No, no, this is the plot number 139. How did physical demarcation? That is whole allegation is, my lord, the paragraph 12
My lord, I-
stated categorically.
But I appear for
No, it
HITCO,
is
if
not
your
that.
lordship
But
kindly takes a
Vivian
look
is
at
there.
the report in the form of affidavit filed by HITCO, my lord, the respond numbers 3 and 4. Kindly, my lord, comes to, my lord, paragraph 7 at page 3.
Will you come back some other day,
Day after tomorrow.
tomorrow?
Day after tomorrow. Tomorrow I have personal difficulty.
Okay. একই তো ল্যান্ড ল্যান্ডটা তো একই।
13th. Short matter can be disposed.
Day after tomorrow, my lord. Tomorrow when I have personal difficulty.
But whenever your lordship.
Heard learned counsels for the parties. Paragraph, let the matter appear under the same heading on
7th.
7th. 77.
I will report a particular charge. I'll put Assad.
Your Lordship, may I be allowed to mention a very urgent matter, Your Lordship? I tender, Your Lordship, I tender unconditional apology, Your Lordship, since the matter involved extreme urgency, Your Lordship. For that, Your Lordship,
Can't you
I,
wait 10:30 tomorrow?
Your Lordship, kindly, Your Lordship, the matter, Your Lordship, the demolition order has already been issued, Your Lordship, by the department, Your Lordship, BDO, Your Lordship. Thereafter, Your Lordship, the BDO, Your Lordship, and the authority, Your Lordship, they will demolish any day, Your Lordship. Kindly, Your Lordship, tomorrow.
Group 7 motion, item number 502.
My lord, I appear on behalf of the petitioner. My lord, on a previous order, there was a direction to renew a bank guarantee that has been given in lieu of the interim order that is already.
Have you done that?
My lord, we have already renewed the bank guarantee, my lord.
Who is appearing for the respondents? No one.
My lord, the railways is the only sole respondent.
Yes,
The railways are the sole respondent.
yes, but I do not find anyone today. Come back after vacation.
My lord, if my lord keeps it next week, we had shown, my lord, all a judgment of Bhaskar Bhattacharya saying that the overlaying of wagons was wrongful. We just have to distinguish the three judges bench of the that has decided finally on this issue.
After that, the respondents also have to make their submission. So that cannot be done in these 2 weeks, isn't it?
My lord, we comprehend that now that the bank guarantee has already been renewed again, the railways will again delay this matter as they have done it in the past. That is one. If my lord fixes it after any day in January also, that will also suffice.
I'll do that. I'll fix it in January. Copy of the renewed bank guarantee submitted on behalf of the petitioner is taken on record. Paragraph, none appears for the respondents. Paragraph, let the matter appear under the same heading on 19 January.
19.
প্রথম গন্ডগোল হয়ে যায় প্রথম গন্ডগোল হয় 23, 24 তাইলে থাকে
এইটা চ্যাট করতে হবে। Item number 503.
Court মামলা court ready হতে পারে।
Yes.
But this matter I just yesterday I have told my lord this matter was entrusted to me yesterday. My lord, I have told yesterday. So then my lord, I have
Will
gone.
some more time.
In that event, my lord, on after my lord 2 or my lord 3 times, my lord, after
Yes, my lord, that I have gone through.
আমি
my lord.
বলছি না তোমার পিটিশন তুমি চুপ করে শোনো আমরা after 2 or 3 times, my lord, giving liberty to file supplementary affidavit because on the very first occasion, on the very first day, my lord, I brought it to your lordship's notice that exactly on similar, my lord, the issue, writ petition filed by the writ petitioner and that was dismissed with a judgment delivered by another coordinate bench. Now, my lord, it was not annexed to the writ petition. Now, my lord, on that basis, my lord, then, my lord, he, pursuant to my lord's, practically what failed by my lordship, then you should disclose all these things. Then he said, I shall file a supplementary affidavit. Then after, my lord, 2 or 3 occasions took time and then file a supplementary affidavit. Supplementary affidavit annexing that particular judgment of the honorable judge of the coordinate bench. Now, my lord, at this stage, my lord, let him take time. I'm not on that. But eventually, on the next day, at least, my lord, actually, I shall pray for time to file affidavit. There is no question of my lord passing any interim order. He wants, my lord, linkage through, my lord, e-Bahon portal. The government e-Bahon portal, my lord, my lord, private individual, he wants to linkage. I do not know where is the law and how he can claim this. In any event, it has been dismissed. Again, my lord, he is that I am the patentee. Now, in the judgment, it is that, my lord, specifically stated that the Patent Act is something else. If you have any right under the Patent Act, you take.
Mr. Mukherjee needs to take instructions on
Now, my lord, may I tell one thing? Now, in that event, my lord, then my lord, kindly give me some time so that I can file my affidavit in this. Because I have to challenge in the, by way of filing affidavit. This point I have to take by filing affidavit.
If the same issue has been decided
So I have to, my lord.
and
so-
that is already on record, so let Mr. Mukherjee come back with necessary instructions.
Only necessary instruction,
The issue has been already decided by
But
the court. It is not by res judicata.
I think so.
But that, my lord, that I have to take because, so for my instruction is concerned, one part that the Mr. Sen, what he is submitting, that in a repetition before the coordinate bench, there is another order, a directions given to the central government, the, my lord, the highway and this, the Department of Ministry of Highway and others, to consider the representations where he, these petitioners therein, this Kanishka Sinha asked for that portal. Remember, that was disposed of with a direction to consider that representation by a coordinate bench. There, that has not been considered as yet. So a contempt application has been filed therein before the the coordinate bench. That is also pending, but that has to be taken into consideration. That part,
But that
particularly.
has not been
That- yes.
annexed to the supplementary.
Well,
affidavit.
that instruction I have, matlab, this matter will appear, matlab, the contempt applicants before Justice, my lord, Justice Bhattacharya, the coordinate bench, that at that point.
So that is why he may take time so far there. He has to
on
wait for
8th,
contempt.
Come back in January.
Well, this month, any day, because only.
no.
if
Then,
it is-
my lord,
if your
January.
lordship, if it is your lordship's find that even the judgment which has been delivered by the coordinate bench, which is under contempt. Now, my lord, if it is that judgment and the other judgment.
Do it right now. Ki masa? No, because my lord,
Only-
ultimately, my lord, an affidavit,
only-
shall pray for
That
affidavit.
is if it is required to be decided on
Very-
merits. only
Yes,
then.
yes, my lord, my lord.
We do not need to go into merits.
My lord, that's why this is not
That's fine.
nothing. Your lordship may dismissed or disposed of whatever be my lord's. My lord,
15 December,
my lord, my lord.
on prayer of the petitioner, the matter is adjourned. Paragraph, let the matter appear under the same heading on 15 December.
And my lord, if any further, my lord, the documents they want to submit, then let them file in the meantime. Because I think, my lord, some documents have not yet been
Documents,
annexed.
My lord, it need not be required to the judgments which my learned friend relying that.
I am not relying. It is his document. He annexed it.
Yes, another
No,
judge.
you are referring to another judgment. Please
That,
produce that judgment on the
my
next
lord, that's why only. And I will supply that judgment where the directions was given to the central government to consider that part.
Yes.
So
yes.
that I will
And
hand
this
over
is,
him a
my lord, this is
advance
the,
copy
this
of that.
is the very, my lord, Lordship, kindly consider, difficulty is that, my lord, relying upon some other judgment, and my lord, the writ petition filed, my lord, 3 pages petition, and rest, my lord, the annexure. But now he say that I shall produce that.
That I know, my lord,
Kindly consider, this
very
is,
cryptic
Let him
thing.
hand over
I
the
know, my
pen
lord,
and
I know, my lord, I.
These are the judgments of this court.
he
My lord.
he
If
could
the
have,
judgment has
he could have annexed to the writ petition, or my lord, annexed to the supplementary
This is
affidavit.
not done, sir.
So she kindly consider this thing.
Mr. Mukherjee has.
Just I have, my lord, 2 days, my lord, that
sir, I think
instruction
it's a
and that
change.
I have gone through, my lord, that I will supply a
Now
advance
that Mr.
copy of
Mukherjee
that
is
judgment.
there, I think all the
Very
documents
good,
will be
my
released. Please serve advance copy.
My lord, I will.
Next.
Number 504.
Lord, 504, my lord, I am for the petitioner. Lord, this matter heard by your lordship of
Mr. Sen for the response.
my lord. On the prayer of Mr. Sen, my lord, last occasion the matter was adjourned. Lord, lordship kindly remember, this is, my lord, regarding, my lord, extra 5%. Second thing, dangerous driving. And third thing, my lord, without valid documents. My lord, regarding extra 5%, your lordship has already passed an order, my lord, in earlier petition. My lord, regarding dangerous of driving, my lord, on last occasion, my lord, I argued before your lordship that the dangerous driving should be mentioned in what manner I was driving, according to the, my lord, present.
Actually, pursuant to your submission, Mr. Sen wanted to take instructions.
My lord.
My lord, no further instruction, my lord, I have received. Only thing is this. The my lord, here, my lord, no penalty has been slapped yet. Nothing has been seized. Vehicle has not been seized, nothing. Only that, my lord, the challan, it was handed over on because of, my lord, the offenses mainly that excess load. So far, the offending vehicle is concerned. And the second thing is, my lord, that the rash driving. And another thing is, my lord, that is my lord, the vehicle attached to it, my lord, the national permit. And my lord, in case of national permit, my lord, that is rule 90 within bracket 2 of the central motor vehicle rules. My lord, according to my lord, the motor vehicle inspector, that has been flouted. Now, my lord, she kindly, my lord, the rule 90 within bracket 2 of the central motor vehicles rules. This is, my lord, the caption is additional condition.
Central motor vehicle.
Yes.
এটা ইনসলভেন্সি ব্যাংক্রাপসি কেন চলবে না ওখানে মোটা সেন্ট্রাল মোটা
90.
রুলস সেন্ট্রাল রুলসটা মোটা হয়ে যাবে
আচ্ছা, ওই চালানটা যেটা হ্যান্ড ওভার হয়েছিল ওটা আপনাদের কাছে
এই তো
আছে?
যে উপরে
ওটা অ্যানেক্সার করেননি না?
না আমি তো দেখেন এখন
আমিও চেয়েছিলাম, আমিও পাইনি ওই চালানটা।
রুল 90
মানে রুল 90 উইদিন ব্র্যাকেট 2 অফ দি সেন্ট্রাল মোটর ভেহিকল রুলস। একটা চালান যেটার উপর বেস করে
দাঁড়ান, 1 মিনিট আমি বলছি পেজ
আমাকে দিয়েছিল, আমি কোথায় মিসিং করেছি।
এইটা বলছেন পেজ 26 দেখুন
এক মিনিট,
পেজ 26
পেজ 26। আচ্ছা, yes, my lord, rule 90 within bracket 2, my lord, the caption is additional condition for national permit.
yes
Now, my lord, rule 90 within bracket 2 speaks that a board with the inscription national permit valid in the states of, that means that should be mentioned valid in the states, with blue letters on white background shall be carried in front of top of such vehicle. That should be exhibited in this way.
yes
But it was also missing according to the the person, the authority, my lord, who intercepted and ultimately, my lord, handed over the challan. Now, another thing is, my lord, the rash driving. Now, rash driving, lordship kindly consider, it's a, my lord, the factual aspect. And my lord, if anybody can say that you prove it that it was rash driving, now, my lord, each and every road is not covered by the CCTV camera till date, or, my lord, that is, my lord, that speedometer. But something has to be, my lord, we rely upon the authority concerned, my lord. And so far the Motor Vehicles Act is concerned, my lord, officers who are engaged on road, my lord, they have some, my lord, power to, my lord, they control the, my lord, I think so that in a disciplined manner, my lord, the traffic can, to regulate the traffic to a disciplined manner. Now, my lord,
I issued the challan
that, my lord, the motor vehicle inspector.
I do not find any signature or anything
চালানটা কোথায়?
This is my lord online challan, my lord.
Yes.
Page
online
26.
challan yes
And my lord, page 27 for a moment, my lord, page 27. My lord, the document status, my lord, it is, my lord, logged by the Islampur RTO, as a result of which my vehicle, my lord, cannot flying, my lord. Flying করতে পারছি না।
Carrying excess load, my lord, I have explained in my report. Have you lordship got it, my lord, in the report filed by the state?
yes
I am not wrong, my lord, on this issue.
না, না,
Mr.
ঠিক আছে।
Sen already argued, my lord.
না, না, এটা কোনো আর্গুমেন্ট হচ্ছেই না তো, শুধু কোর্টের নজরে আনছে, আর্গুমেন্ট আবার কোথায়? না, লর্ডশিপ কাইন্ডলি, মাই লর্ড, come to paragraph 6. My lord, paragraph 4, lordship kindly.
yes
Have you also got in a paragraph 4?
Yes.
Paragraph 4, my lord, the sentence starts upon comparison, the second sentence in the middle, upon comparison of said women's slip with RC book, because the vehicle was asked to, my lord, put on women so that the actual measurement, and he cannot deny that the actual measurement slip, what, my lord, it denotes that what is the actual measurement. Wait, upon comparison of said women's slip with RC book, it appeared that the vehicle was carrying excess load beyond permissible limit. In terms of notification dated 16 July 2018, issued by Ministry of Road Transport and Highway, the gross vehicle weight of such vehicle in no case shall exceed 49 tons in case of rigid vehicles. Admittedly, the GVW, that is gross vehicle weight, noted in the said women's slip 49,560 kg. Now, my lord, kindly come to the page 6 of the affidavit, annexure of that 6th August 2018 notification. I think that is the last annexure.
Yes.
But that notification, if you lordship kindly come to paragraph number 2, the gross vehicle weight GVW shall not exceed the total permissible safe axle weight as above, and in no case shall exceed 49 tons in case of rigid vehicles. So in any event, whatever be the, my lord, it appears from the, my lord, the, RC book, where GVW mentioned there in gross vehicle weight in the RC book. Whatever be there, as per this notification, in a rigid vehicle, 49 tons maximum. Here it appears, after putting the same on that women bridge, 49,560.
That is within the 5% relaxation.
Yes, that is their case. That is their case. Whether, my lord, can accept it or not, because 5% at the bottom explanation, for the purposes of this notification, tolerance up to 5% in the gross vehicle weight shall be allowed for the purpose of compliance to subsection 3 of section 113 of the Motor Vehicles Act 1988. Now, if we read that section, my lord, 113 of the Motor Vehicles Act, along with this notification, then, my lord, that 5% exemption he is entitled to.
Yes.
But if the, my lord, the upper portion, that is the table, what is mentioned herein, the table, my lord, lordship kindly consider, the Pacific, my lord, single axle 3.0 ton, single axle then 7.0 ton, that is 2 tires, 4 tires, and in this way, my lord, Pacific, my lord, against any prescribed or, my lord, in every prescription, whatever, so that the manufacturer, the body manufacturer and other thing, then, my lord, the weight mentioned therein.
So the maximum weight is 49 tons.
But the maximum, then this maximum explanation and or expression, the maximum, whether it can be, my lord, again, my lord, this maximum can be curtailed, this meaning and or this expression, its scope by, this is, I leave it to your lordship.
The same notification.
No, I
and
leave it to your
the
lordship.
explanation says for the purposes of this notification.
Yes.
So that means he is entitled.
Yes. So I leave it to your lordship.
In terms of this notification.
Now, my lord, and my lord, so far the, my lord,
So that part goes.
that part may go. I leave it to your lordship, my lord. I cannot say go, but I leave it to your lordship.
Second time, my lord, this argument is making my life.
আরে এটা তো লয়ারের কাজ কি মুশকিল
না না আপনি বলুন
একই
না।
কথা বারবারই বলবো
না না বলুন বলুন।
Now, my lord, another thing is this, then, my lord, the rest of the offense with regard to, my lord, that, my lord, কি আছে ওটা? Dangerous driving. But that is, my lord, the factual aspect. how read court can go into this, my lord. That is the, my lord, because it is very difficult.
How do you prove dangerous driving? It's difficult.
My lord,
And there is no explanation also. Only one line, dangerous driving.
yes, there is no scope for any further explanation. There is the mention therein that the dangerous driving. Dangerous driving means that, my lord, that the whatever the maximum speed, much more than speed, he drove away,
Lordship, kindly-
driving in excess speed.
My lord, I relied on unreported judgment, my lord, Justice Bhattacharya's judgment, my lord. Where, my lord, Justice, my lord, that term, my lord, dangerous driving without any, my lord, documents or proof is a, my lord, vague. My lord, so far I understand, my lord. So, my lord,
And the other part is any transport vehicle plying without permit
yes,
or invalid permit or
My-
violation of permit.
my lord.
Violation of permit is this. What I have drawn your lordship's attention, my lord, to my lord, Rule 90 within bracket 2.
How can it be violation of permit because permit was issued?
No, violation of terms of permit. Violation of terms of
Where
permit.
is the permit?
My
That
lord,
is the national permit.
Permit, my lord, 23, page 23,
National
page
permit.
24. And downwards, my lord, it is, my lord, all up to, my lord, valid 20th November
No,
2027. See, my lord,
there
what-
are some other, my lord, conditions mentioned under the rule. Mentioned under the rule. Lordship, kindly, my lord, come. That is why, my lord, I have drawn your lordship's attention to Rule 90 within bracket
Where is
2.
it stated that this is a national permit.
National permit. Now, additional condition for national permit mentioned in the rule book. Mentioned in the rule book. And that is, my lord, rule 90 within bracket 2. My instruction, the violation of this. A board with the inscription national permit valid in the state shop with blue letters on white background shall be carried in front of such vehicle. That was missing.
Where is this stated in the challan?
No.
So it is vague, cannot be considered.
My lord, kindly, my lord,
On these issues, actually, you wanted to take further instructions. There should be
my
some
lord,
detail.
my lord,
Otherwise, it goes. The entire challan goes.
very good question. Kindly, my lord, because
It is very
even
vague.
if I even if I take instruction, the same instruction I will
Further-
receive. No further improvement because unless there is a photograph, unless there is a photograph of the vehicle when it was intercepted,
It's necessary.
there should have been a photograph or in this way. In absence of that, my lord, by argument, I cannot improve that this is my instruction. Instruction already on the basis of which, my lord, I have prepared that, my lord, the supplementary affidavit. ও ওইটার জন্য বুঝতে পেরেছি হু হু করে হাওয়া আসছে
সব ঠিক আছে।
কি বলছে জাজমেন্টে আপনার
আচ্ছা,
কোথায় আপনার এই জাজমেন্টটা কতটা অ্যাপ্লাই করছে কেন এই জাজমেন্টটা
আচ্ছা, আপনি 13 নম্বর 13-14টা পড়ুন, নিচে দেখুন রেজিগনেশন নিচে আছে, রেজিগনেশন নিচে আছে পেজ 13-14, 13 মাঝামাঝি থেকে শেষের দিক থেকে 12 বারো 13 দেখুন 13 ঠিক আছে 13 আপনার এই 190 সঙ্গে আমার 190 মিলছে না কেন? 190 সঙ্গে আমার
The judgment referred is deals with compounding of offences.
Yes. Unreported judgment. This is whether that, my lord, the compounding offense, naturally he has to agree, otherwise the matter referred to the court.
Yes, yes. This
Yes,
primary
yes.
deals with that.
Yes.
So let there be an order. Yes, do you have anything to add? No. Heard learned counsels for the party.
আপনি তো পয়সা দিয়ে কিনেছেন, আমাকে তো গিফট করেছে, কি করে মিলবে? না সেকশন না রুল স্যানিটারি মোটর ভেহিকল রুল।
এই যে দেখুন তো এইটা কিনা আমি ভুল দেখছি কিনা ছেড়ে কথা বলার লাগে কথা বলার ছেড়ে
Petitioner has essayed the e-challan issued by the respondent authorities against him on 10th May 2023.
কি আছে, অসীমা আছিস?
The challan slaps a fine of rupees 41,000 upon the petitioner on threefold grounds, : next line I, small I, carrying excess load, within bracket fine rupees 26,000. Number 2, driving dangerously, within bracket fine rupees 5,000. And III 3, any transport vehicle plying without permit / invalid permit or violation of permit, if permit required as per 66 of MV Act, within bracket fine rupees 10,000. Learned counsel for the petitioner submits that
my lord, may I leave, my lord?
the gross vehicle weight of the vehicle was well within permissible limits. Stop. The alleged dangerous driving is vague and has not been proved. Stop. The permit of the petitioner is valid up to the permit is at page page number
না এটা সার্টিফিকেট অফ রেজিস্ট্রেশন।
Oh, it's page 21. Page 21. valid up to 20th November 2027. Stop. As such, comma.
Page 21 is
Yes.
the, my lord,
It's
the
20th November 2027.
page 21 is certificate of registration
Page 22 is the,
and page 22 is the permit.
yes,
Permit part B.
yes, yes. It's valid up to 20th November
Yes,
2027.
yes.
As such, comma, the e-challan
And my lord, 22, my lord, it should be, my lord, along with 24, because 24 is part A. Permit must contain part A and part B.
I was just
Yes,
I
any.
put the date.
Yes, yes, yes.
As such is without any basis and is required to be quashed. Paragraph.
Yes.
Placing reliance on the report in the form of affidavit submitted by the fifth respondent, comma, learned counsel for the respondents submits that the vehicle in question was carrying excess load beyond permissible limit and also, comma, there has been violation of Rule 90 of the Central Motor Vehicles Rules 1989 in so much as the words inverted comma mode national permit or N/P, capital N/P, N national, N/P, inverted comma closed, was not inscribed in the front and rear, REAR, rear of the vehicle in bold letters. Paragraph. The notification issued by the Government of India, comma, Ministry of Road Transport and Highways on 6th August 2018, comma, relied upon by learned counsel for the respondents, demonstrates that the gross vehicle weight shall not exceed the total permissible safe axle weight, AXLE, safe axle weight as above, and in no case shall exceed 49 tons in case of rigid vehicles. Stop. The explanation to the said notification says that for the purpose of the notification, comma, tolerance up to 5% in the gross vehicle weight shall be allowed for the purpose of compliance to subsection within bracket 3 of section 113 of the Motor Vehicles Act, comma, 1988. Paragraph. In the present case, comma, the gross vehicle weight was found to be 49,49560 kgs. Which is within the %5 relaxation granted in the notification dated 6th August 2018. Therefore, it cannot be said that the vehicle was carrying excess load at the relevant time. Paragraph. Dangerous driving, এটা inverted comma মধ্যে, has been dealt with in section 184 of the Act of 1988. Stop. According to the said provision, comma, dangerous driving includes driving of a motor vehicle at a speed or in a manner which is dangerous to the public or which causes a sense of alarm or distress to the occupants of the vehicle, comma, other road users, comma, and persons near roads. Stop. The e-challan merely imposes fine of rupees 5,000 for dangerous driving and does not substantiate such act on the part of the driver of the vehicle. A solitary statement of dangerous driving without any supporting evidence is far from sufficient to impose fine of rupees 5,000 for the same. Paragraph. Though the respondents have tried to impress upon the court that the petitioner has violated the conditions for national permit as laid down under Rule 90 of the 1989 rules, comma, the said allegation has also not been proved. Stop. No photograph of the vehicle has been taken by the authority to substantiate violation of the said rule by the petitioner. Paragraph. In view of the above, comma, this court is inclined to hold that the e-challan issued by the authority against the petitioner is devoid of supporting evidence and is therefore required to be quashed slash set aside. Paragraph. The writ petition, accordingly, the writ petition succeeds. Paragraph. The e-challan issued by the motor vehicles inspector within bracket non-technical against the petitioner on
copy
10th May 2023 is set aside slash quashed.
কত থেকে কত আছে হাত পা ছুটছি আমরা
Paragraph. The respondents are directed to unlock the vehicle search website of the petitioner in respect of vehicle number WB 59C 9880 in order to enable smooth plying of the vehicle by the petitioner. In order to enable forthwith of the petitioner forthwith in order to enable. There shall however be no arrest costs disposed of allowed succeeds repetition disposed of চারটি line.
Hello. Number 505.
This is my report. So, some relevant documents are required placed in this writ petition. So, I don't want to proceed this writ petition. Can give it regarding to what we placed in the center of parliament.
He wants to withdraw with liberty. So you can take back the report.
Yes, yes, yes.
Mr. Deep, take back the report then. The next writ petition.
Two copies each.
He is withdrawing with liberty.
Report be kept on. Department asked me why.
Report in the form of affidavit submitted on behalf of the state respondents is taken on record. Paragraph. The petitioner seeks to withdraw the writ petition on account of certain defects detected therein and seeks further liberty to file a fresh writ petition on the same cause of action. Paragraph. In view of the above, comma, the writ petition being WPS such and such is dismissed for not. Paragraph. Liberty is granted to the petitioner to file a fresh writ petition on the same cause of action. Paragraph, there shall however be no order as to costs. There shall however, আপনি however টা আগে দিয়ে দিচ্ছেন সব জায়গায়। There shall however be no order as to costs.
Deep level.
Item 506.
In this matter, I am appearing for the petitioner and led by Mr. Subrata Mukhopadhyay. He is appeared online.
Yes.
My lord,
This is my
the substance of the writ petition is this.
Have you seen the copy of the report?
I have gone through the report. Now I
Right.
want to file, my lord, rejoinder, but prior to that, I like to draw your lordship kind attention. Virtually, by filing this report, they have admitted our allegation. Why?
You said you want to use a rejoinder.
I want to use rejoinder because of the reason the allegation made by us by filing the writ petition remain uncontroverted. On contrary, they say in their report that a good number of vehicles are flying illegally without having any permit, without having any license, without insurance since 2019. Now, they say that we have issued a notice, memo, which is under challenge to regularize. Now, I put this question to myself, subject to correction by my lord. When admittedly government say by filing a report in the form of an affidavit, yes, there are irregular, illegal vehicle are flying. Whether that notification is sustainable in the eye of law, that is the question. Your lordship can hear me, or your lordship may fix without directing them to file affidavit, or your lordship may direct. But kindly injunct them, restrain the government not to allow those auto to fly from the route.
I believe the government has taken steps to restrict them. Mr.
My
Dev,
lord?
the government has taken steps in this regard.
No, has taken notification issued in
No.
terms of the court's order. Division bench
What
order.
notification?
Without permit, those who are operating their vehicle kindly regularize their
Please
vehicle.
take the microphone, he'll not be able to hear you otherwise.
Oh. Illegal without permit vehicle can be regularized by way of notification. There is a notification issued in terms of the order passed by the division bench of our court. Why?
Very good.
Yes.
Supply me a copy of the same. That cannot be.
He
If
has
I
to put there.
unauthorized construction and they say kindly regularize.
And
Use your rejoinder, I'll take up the
and
matter.
lordship directed
my-
to file a report, not affidavit opposition. That is why, my lord,
He wants to use a rejoinder to the report, let him come back.
My lord. And my lord, I request my lord, your lordship may request my learned friend to stay because they have not indicated what is the division name. If they indicate to my junior, I can go through it.
Mr. Devra, can you please indicate the judgment of the division bench because learned counsel is not aware?
Mr. Sen is there, my lord.
My lord, may I tell, my lord? Yes, I have understood, my lord, since I am here, I have understood. My lord, because our duty is to, my lord, that the, my lord, to, my lord, our duty, my lord, is to, my lord, so that the justice can be done, my lord.
Say the number, say the case number, Mr. Sheikh, matter comes to an end.
My lord, may I tell? My
I
lord,
go through it, I file rejoinder.
Mr. Saharai, my lord, Mr. Debroy, my lord, you may not know, I mean, my lord, the earlier policy, same policy was challenged before a coordinate bench. Now, my lord, they could not succeed. And my lord, it was held by the court, by my lord Justice Talukdar, as his lordship then was, that government can frame the policy for the purpose of regularizing the unauthorized movement of the vehicle. Government can. My lord, that was, my lord, held, and my lord, that judgment was, my lord, assailed before the division bench. Now, my lord, the division bench, my lord, said that the policy is all right, but only thing is this, that in the policy, you cannot accommodate only the irregular or illegal, those who are plying, those who do not have any permit, because the strength of the route, after having been mentioned, you cannot say that all the vacancies should be filled up only by giving permit to the those who are plying illegally. So there should be a percentage. Suppose 40%, 50%, court did not say, but it fell from the court division bench. There should be a percentage. That to what
Mr.
extent?
Chain, kindly say the division bench judgment number.
Yes,
Please.
yes.
There is no scope for on your part.
Now,
I'm not afraid about you to address the court right now. If you can go through it. I can argue it.
Let him complete,
No
sir.
problem.
It is his habit. We are friends after all, I know him. Now, my lord, the after all division bench disposed of the appeal without interfering with the judgment of the learned single judge, but with a rider that the authority should take a decision with regard to the percentage, so that a phrase who can apply appraise how they can also accommodate, because the number of permits to be given are mentioned therein. After that, my lord, the second policy they introduced, and I have gone through the second policy on several occasions, almost same. So let him, my lord, produce. I can help him the copy of the
Both the
order,
judges.
yes, of the single judge,
And
division bench, yes. আর তুমি একে ওকে সুব্রতকেও দেবে? হ্যাঁ 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 আমি তোমায় দিয়ে দেবো।
Milord, only thing, sorry for interruption, Milord, kindly excuse me. Only injunction I'm playing, Milord.
No question injunction.
Yes.
By this time, Milord, kindly restrain, not to ply.
No, not necessary. Please come back.
Policy decision, how can it?
Learned counsel for the petitioners seeks to use a rejoinder to the
হ্যাঁ 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 এই নোটিফিকেশনে
Paragraph
আগের
let the
নোটিফিকেশন
matter
হয়েছিল
appear under the same heading
2020 না 2018 সালে 2018 থেকে চ্যালেঞ্জ হয়েছিল।
10th January.
আমাদের
এই
2020.
রকম মনে করে দিও, আমি তোমাকে বলে দেবো।
পিটিশনের মধ্যে
Please serve an advance copy.
তোমাকে বোধহয় আমি একবার
Now, the judgment may be served.
Yes.
আমি
The judgment they have relied, although it is not reflected from the report, Mr. Devrai. At
Learned
least,
counsel will hand over a copy to you.
my.
Yes, next matter. Next matter.
Item 507.
রিপিটে দিয়েছিলাম।
I am appearing.
রিপিটে দিয়েছি। সেইটা যেখান থেকে গেল সিঙ্গেল
ও দিয়েছিল
ডিভিশন বেঞ্চ ওকে আমি দিয়েছিলাম।
তাহলে ওর মধ্যে সিঙ্গেল পেয়ে যাবো তো।
In the earlier occasion, I filed a supplementary affidavit. But initially, I challenged the decision, which was not published. But afterwards, since it has been published, I have made a supplementary affidavit wherein the impugned order is there. This is the affidavit of service.
So this is affidavit of service.
So Lordship, kindly come to the supplementary affidavit first. This is the impugned
Mr.
order.
Debra, you are ready today? Mr. Debra, you are appearing in this matter?
I'm
You are ready today?
I'm ready.
Yes.
That
Supplementary.
page 12.
What is the matter about?
Matter, my lord, I applied for grant of permit in respect of an interstate route Siliguri to Ranchi, sometimes in the year 2022. But I made 2 applications against the 2 vacancies. But afterwards, it seems that 1 vacancy is there. I have been granted. And I produced new vehicle, my lord. My lord, offer letter was issued, pursuant to that offer letter, I produced the vehicle. Since the registrations of the vehicle was not made ready, my lord, within time I could not submit the registration mark of the vehicle within time. No decision was taken. I made representation that I have already, body has been already been built up, kindly issue permit. No decision has been taken. On the other hand, my lord, I was asked to and my second application was not considered. At all, I had not yet been disposed of.
There was 1 vacancy, you said.
1 vacancy.
But I made two applications,
For two separate vehicles.
two separate vehicles. But thereafter, all of a sudden I came to learn that a meeting was held against declaring one vacancy in respect of the self-same route. But in that meeting, my lord, I have been discarded. On the other hand, one application which was filed before my application, which has been granted, my lord, which has been granted. No merit, my lord, no decision has been taken on merit, my lord. No comparative comparative chart has been taken up as per law, but only the application is on the first in, first out method, my lord, this application was allowed. My second application was not considered in the earlier board meeting, that was pending. If that is so, if that is, since that is the pending, that is the much before than the application of the grantee. Number two, my lord, my application, my representation has not been considered against that grant. Not till then not been granted. But without granting, without considering my representations for issuance of permit, well, they declared they granted permit to the one another operator.
Permit has been granted.
Grant has been made, but not has been issued. My lord, another thing, my lord.
So
There is a notification.
have you implemented that person as a party to the writ petition?
But unless your lordship allow me, because my lord,
I cannot. Why will I allow you? Because
in supplementary affidavit,
his interest will be affected.
Yes, my lord.
So he has to be added.
Yes, my lord. Your lordship kindly have the page 12 of my supplementary affidavit. This is the improved resolution.
Have you added him? No.
No, I could not.
Page 12 of your supplementary affidavit.
No reason, my lord, has been assigned. No reason. My name is Mrs. Adda Shakti Transport.
And it has been granted to Shamoli Parivahan.
Shamoli Parivahan.
Please implead this for this company as a party and come back.
It
Because if you succeed, he'll be thrown out.
It should be. It should.
His interest will be jeopardized. Mr. Devra,
but at the time of making applications for this resolution was not passed.
I understand. But
that's why supplementary affidavit.
I'll grant you liberty.
Yes, ma'am. Well, only interim measure, man, I'm seeking, my lord, till the disposal of this application, no permit, should be issued, my lord.
Why? One vacancy already filled up. The question of further permit, it's the intercept permit.
His earlier application is
earlier with the lordship only see. This is the resolution. Page 12. Second page. Member of
page 12 of?
Page 12 of is supplementary.
Supplementary affidavit. Yes. Yes.
Members STA second. First paragraph. This is an STA board. One quota, one vacancy. So STA board allowed the earlier application. They considered and allowed the earlier application, Mr. Shamoli Port. He has been directed to so license notification number within 30 days, STME allows such extension so. Next paragraph. Member STA decided to reject the latter application of Mr. Adda Shakti Transport Company. Members of STA observed that two applications of Mr. Adda Shakti Company by number so dated so for interstate permit on the route Siliguri to Ranchi via so were placed before the STA in meeting dated agenda number 6. As there was one vacancy out of 3 quotas on the eastern route, members of STA decided to consider the earlier application of Mr. Adda Shakti Transport Corporation as approved, but members of STA did not decide to reject the another application of Mr. Adda Shakti Transport Company. Already they have decided because they have failed first application, they have allowed and they have rejected on the ground that they have failed to produce the vehicle within the specified time as mentioned.
But annex P7 of the writ petition, my lord, page 80, that has not yet been considered. That is by prayer for issuance of permit. But without disposing it up. Without disposing it up, your lordship kindly have a look at page 80 of my writ application.
Where is the order of rejection? This is only stated that by mistake it was not done. Where is the rejection order?
No order.
So no permit be issued till the matter is considered.
Yes, my lord. No further permit be issued.
No permit. This permit will not be issued. It has
No,
not
it has been issued.
Permit
Family
has been
Parivahan
issued.
already issued.
Already granted, not yet it's been issued.
Already granted.
Granted, not yet been issued.
Already granted.
Grant has been made in my favor in earlier occasion.
I take instruction, my lord, tomorrow, lordship kindly keep it, tomorrow I shall take instruction regarding rejection. Why this rejection order?
Not only rejection, you say that the permit has been granted.
Granted, permit has already
But
been granted.
not issued.
Not issued.
He has to.
Issuance and grant is
Different.
Different. Permit has been granted, my specification.
But not to
Since
issue
it is
permit.
not issued, let it not be issued till the matter is settled, disposed of.
If not issued, then not
If
to
not
issue.
issued. If not
Not
issued,
issued,
if
yes.
not issued. Ah.
On prayer of the petitioners, liberty is granted to implead Messrs. Shamoli SHYAMOLI,
Family sir, the
Poribohon Private Limited.
His address has not been mentioned, my lord.
No, but please give the address.
No address has been mentioned in the resolution. Where from I could get, my lord?
From the authority.
আমি তো তো স্টেতে রেগুলার যাস সেখান থেকে পেয়ে যাবি
ধর্মতলা বললেই চলে
না না ওদের অ্যাড্রেস আছে আরে জানে সাতপুরাতে রেগুলার এসটি
Please
অফিসে
give the address. I'll not pass this order till then. একটু wait করবেন, উনি পুরো অ্যাড্রেসটা দেবেন এই। As respondent number 4 in the writ petition,
ওয়েবসাইটটা দেখ না
the paragraph, the petitioners are directed to serve copy of the writ petition along with annexure thereto.
Along with supplementary affidavit.
এখানে
Yes.
রয়েছে
Along with supplementary affidavit.
A copy of writ petition along with annexure thereto and the supplementary affidavit.
But I got the address, my lord.
Upon, please give it immediately. Upon the added respondent and file affidavit of service on the adjourned
এটা
date.
পেয়ে যাবে দেখ।
Stop.
পেয়ে গেছি।
বলে তো অ্যাড্রেস পেয়ে গেছি।
Paragraph since
My lord, read petition paragraph page 80, my lord.
since it appears from
তো আমাদের এখানে রয়েছে।
a resolution taken by the State Transport Authority in its board meeting held on 18th August 2023 that permit has been granted in favor of the added respondent in the route.
No, grant has been mentioned, only allowed. His application is allowed only. First line,
হ্যালো কবে দেখ কবে যেটা
but considered and allowed.
It appears since থেকে কেটে দিন নতুন প্যারাগ্রাফটা ওটা ফ্রেশ বলছি it appears that this is during pendency of the writ petition, that during pendency of the writ
18th August
petition
2023 resolution.
also this is prior to the writ petition.
But it has been published in the website after all, after that.
Yeah, it appears that an application for issuance of permit made by the added respondent has been allowed by the respondent by the State Transport Authority by resolution taken in a board meeting on 18th August 2023. Stop. Since the petitioner claims issuance of permit in respect of the single vacancy in the said route, comma, the respondent authorities are restrained from issuing permit in favor of the added respondent in the said route until further orders. Paragraph, let the matter appear under the same heading on 19 January.
19 January. Fine.
Team privilege.
19 January.
Next.
Then 508.
Well, I have submitted the address, my lord.
Address in the website. That's
It's easier now.
easier. Very.
I'm real expert.
Yes. Service.
I'll not disturb your lordship much, my lord. I'll take your lordship straight to my
You
lord.
are appearing for?
The petitioner. I've served, lord.
What about the respondents?
Intervene.
My lord, intervener ke diye diyeche.
Respondents?
No. Well, I appear for the state.
My lord, I am the intervener. My lord, I have filed an application for addition of party.
Where is your
Copy has-
application?
Yes. That.
When did you file your application?
My lord, I.
For Kaisina.
Yes.
Have you received copy of the application for addition of party? It's not in the file.
No, he just filed.
Asit Shantanu?
My lord, will kindly take page 152 for a moment.
Please wait.
Part of the October.
কি বলতে চাইছে addition of party হয়ে?
কি বলতে চাইছি মানে there are several issues which has not been disclosed and suppressed, my lord. In my
Okay, original
application,
draft.
your lordship will find. Even I haven't got the copy of the writ petition, even I filed this, my lord. I am a necessary party, I am the
You will
petentiator.
not get the copy unless this petition is allowed.
এই কপি দে আমাকে এটা। জেরক্স করিস নি কেন? পয়সা কত?
Addition of party copy কি দেব? সবাইকে
Who wants to be added?
সবাইকে না।
Oh, Mr. Sinha wants to be
My-
added.
I appear for the state.
Any objection to this addition of party? Let this be allowed.
My lord, will kindly take it.
Not ready, sir. Serve a
My lord,
copy.
your lordship has,
Please
my lord.
serve copy of the writ petition to the added party, otherwise not possible. He'll require a copy.
Earlier occasion,
Where
my
is
lord,
the
repeat.
application original?
ওটা দিয়ে করে দিস। আমি
Give me a minute, please.
করবো, দুটো করবো।
আছে original application টা file আছে?
এইটা হবে আগেরটা, এইটা। মাল পেলে তোমার আমার সরকার আমার শুনুন দাদা, দুদিন পরে
This is numbered as can 1. আসেনি? এটা রেখে দিচ্ছি তাহলে। এটা just,
My lord,
The application being can 1 of 2023 is not in the file. A paragraph, the copy of the application. Who has given this? This is your copy.
no, yes, yes.
So you'll.
may I
No, I have not.
It will remain in the file.
may I hand over one copy is with me also. দাও আমাকে দিয়ে দাও।
But it
Have
is-
an-
Sorry. I'm
All the same, all the same. A copy of the application produced before this court. How to start copy of the application produced before this court. পেয়েছেন? দরকার নেই, কিন্তু দিন এটা। Can 1 order করুন আগে? The applicant seeks to be added as a respondent in the writ petition on the ground that he is a necessary party hearing. Paragraph, by consent of the parties, the application is allowed. Paragraph, the applicant be added as respondent number 5 in the writ petition. The cause title of the writ petition be amended accordingly. A copy of the writ petition along with annexure thereto para kore be served upon the added respondent in course of this day. In course of this day. Shall we deal with the writ petition, Mr. Mukherjee?
My lord will record it. I'm handing it over here and now. I'm handing over a copy here and now because it's very difficult to serve here.
No, let me hand it over, but that cannot be here and now. I cannot answer here and now. Well, there are several issues that has not been, but that was suppressed in this writ petition, my lord.
My lord, will kindly, my lord,
No,
allow
no.
me to place what page
Okay.
150
Your
for a
lordship
moment.
Limit of services. WPL. He wants to come back, sir.
My lord, what I want to tell your lordship, my lord, earlier Mr. Sinha appearing in department has consented to the order.
Where, in this matter?
My lord, in similar matters, he has appeared in
Maybe.
person and consented.
Maybe, but don't you think he requires an opportunity to go through the writ petition?
Very well. Well, I'm giving a copy here and now. My lord, can you
Do that.
record it?
I have recorded that.
And my lord, your lordship, kindly see these voluminous copy today he has given, and I will.
Mr. Mukherjee, it looks voluminous. You are also aware that it's the same matter.
No, that is the difference that I will argue. It's a altogether different thing.
So he knows everything.
Yes.
No.
This was different.
My lord has directed the matter to appear on
January.
My lord, before puja, my lord, I have filed, my lord, I am suffering, my lord. Kindly, my lord. My lord, if necessary, in the last week, my lord, third week, my lord, because I am suffering.
Very well, 20th.
20th.
WPA te order karo. Let the matter appear under the same heading on 20th. 20. December. Yes, next.
20th March.
Item number 509.
Lord, I appear for the petitioner in this matter, my lord. Lordship.
Yes.
Lord, the private respondent has been served, my lord. Page 24 is the objection against flying of vehicle beyond 15 years in violation of the notification. That too, another reason is the vehicle was initially registered with the same chassis number and engine number before the HON'BLE. And this vehicle, after demise of the registered owner, now subsequently it has been registered within Murshidabad RTA, having a same chassis number, engine number with different number. It cannot be done.
How are you affected, sir?
First, I am the operator. I am the operator in the restricted field, and someone is flying the vehicle in the road, in the restricted field, beyond 15 years of the completion of the age of the vehicle in violations of the order passed by this honorable court as well as the notification.
Report that the private respondent's return is left without instruction. So this is not service.
Lord, I could not check up the. It has not been served.
Left.
It has been served.
You are appearing for the private respondent. Oh, that solves the problem.
My only submission, let the authority be directed to decide the objection upon giving hearing to both parties.
Who is appearing for the authority?
State, I don't know. But
State is served.
Yes, state has been served. State has been served, Lord. Notice is there.
Mr. Debra, may I request you?
Please, I will give a copy to Mr. Debra. Let it be decided by the authorities.
I have some objection. I have to file the matter. This is an allegation, a serious allegations. No, matter I have to, because I have to file the affidavit in that.
The authority will decide.
No, but what authority will decide? He is alleged that I have done some fraud, and that fraud will not be decided by the authority.
The fraud will not be decided by this court also.
So that's the main thing. That means the fraud will not be decided by the jurisdiction of this court. Then I have to file the.
I'll leave all the issues open. I'm not going into merits at
My
all.
lord, let me allow. My lord, at least, my lord, I have received this, that I have disclosed that I received it. Yesterday, my client has handed over this. And my lord, let me any other day.
The objection
I have to
needs
take.
be
My lord,
considered.
Your lordship,
Are required. I will not.
registering authority is the appropriate authority to decide whether a vehicle can be registered twice to number.
Required.
Now, my lord, who is the authority?
Whether fraud is there, it is be detected by the registering authorities.
Yes,
it has
then
to be
who is the
detected.
authority? Registering authority.
Registering authority.
Now, my lord, who has been where is the representation made? Let it see.
It is flying under the permit issued by the secretary.
Forget about this. Who is the registering authority? My lord, your lordship, kindly see where
the secretary will call for the records
made
from the registering
then
authority.
who will decide whether the fraud has been done or not? Even then,
whether a
not the
vehicle
permit
can be
issuing
flyed after 15 years.
Let the
whatever
ID
be, my lord.
Let the registering authority decide the fraud.
Two issues that permit has been granted against a vehicle which is the initial registration date is 2002. Now it is more than 20 years, whether this permit can be issued by the STA against a vehicle which has completed the age of more than 15 years. Second issue is how the vehicle having a safe chassis number and engine number has been registered twice, initially with the Hooghly and subsequently with the registering authority Murshidabad. The STA is the superior authority. They shall call for the records from the registering authorities to decide the issue. Two issues: whether the vehicle can be prior beyond 15 years in violation of the notification, and second issue is the STA will decide whether the permit was granted to the persons in terms of the provision, complying the provisions of the Act and all. That is to be looked into after verification of the records, how the vehicle has been registered twice with two registration number with a different number. The STA is to decide first.
Let page 24 be decided. This court will not go into merits.
Page 24.
Take it
Your lordship kindly appreciate. But the statute itself very clear. There are two separate authorities.
I'm not
Now,
going to that
then
at all.
who has to decide whether who has detected the fraud?
Now this.
The STA will detect the fraud. Is
If
it be
they-
considered
if
by
they
the
cannot
STA?
detect the fraud, they'll transfer it to the other authority.
My lord, your lordship kindly see.
Why are you
Even my lord, in the area of respondents, there is no mentioning about the registering authority. Your lordship kindly see.
Not necessary.
Your lordship
The
kindly see.
secretary
These
decide.
type of writ petition.
STA has enough power to call.
Affidavit of service. The petitioner
My
for consideration
Well,
of,
got it.
in some other matter, not in this matter. The petitioner prays for consideration of his objection filed before the Secretary State Transport Authority, West Bengal on 7th April 2023.
পরেরটা হয়ে যাবে পরেরটা হয়ে যাবে ডাকানো হয়ে যাবে পরেরটা
Paragraph. The petitioner appears to be a permanent stage carriage permit holder
বলে দে এখানে
and has made certain allegations against another vehicle plying in the same route.
Yes.
Paragraph, since the objection filed
in
by
the
the
allied-
petitioner is pending since.
My route is slightly different in the allied route, but covering the certain portion common.
Plying in a route, portion of which overlaps the petitioner's route. তারপরে, since the objection filed by the petitioner before the authority is pending since 7th April 2023, the writ petition is disposed of, directing the concerned authority being the
দেখো possibly fourth respondent.
I just see. The fourth respondent herein, to consider and dispose of the objection dated 7th April 2023 within 1 month. Within 1 month from the date of communication of this order, upon affording reasonable opportunity of hearing to all concerned, including the petitioner and the private respondent, in accordance with law.
Only one.
Paragraph, the decision taken by the authority shall be communicated to the petitioner within a week thereof. Paragraph, it is made clear that this court has not gone into the merits of the case, and the concerned authority shall be at liberty to deal with the objection independently in accordance with law. Yes. Mr. Debray's appointment regularization not appears. Other matters tomorrow.
But subject to lordship indulgence. But next matter is a simple matter, although I am a respondent, is to be considered by the secretary. But tomorrow, personal difficulties, and day after tomorrow, I will not be coming to the court. And my another prayer is, I have some matters in group 7 matters, and my junior will be there. You will also kindly accommodate me for 1 day only.
Please make your submission.
Yes, my junior will be there.
For the petitioner, my lord. So let matter be taken up on Friday, my lord, because tomorrow he will not.
Yes, madam.
Please make your submission, I'll consider.
Well, let it be taken up on Friday.
Let your junior.
Or by
court
my
appear,
junior will be here, it can be disposed of by sending the matter to the authorities for disposal.
Be dealt with tomorrow also.